seats on that side. Welcome to the Appellate Division, First Department. We have a very large number of cases requesting argument time today, and there are almost 8 hours of argument time requested. I therefore ask that you only ask for the time you need, and I want to let you know in advance that you might not get as much time as you want because of the number of complicated cases and the number of cases requesting argument time. But be assured we have carefully read your briefs and are familiar with your arguments and will carefully consider the records when deciding all the appeals. People versus Clark, appellant. Respondent? I'm going to make it 2 and 1 and 2. Harmon Agency versus Wilhelmina.
For appellant, 1.5 and 2.
I'm sorry, what are you asking for?
1.5 minutes and 2.
1.5 and 2. Thank you. Clark versus Fifth Avenue Development. Respondent? 5, 1, and 4. Ugo Alum versus NYS DMV. Appellant?
5 and 2, Your Honor.
Respondent? 2 minutes?
Yes, please, Your Honor.
I'll make it 5, 1, and 2. Singh versus New York City Housing Authority. Appellant?
3 and 2. Your Honor, respondent for respondent 0, 3 minutes. Respondent 2 minutes.
I'm going to make it 3 and 2 for appellant and 3, 2, and 2 for respondents. PA Infant versus New York Presbyterian. Do you want to just submit since the movement is not here?
The movement made a filing last night.
I'm sorry, the movement what?
The movement made a filing last night. The appellant, so I would like to submit it.
You want to submit it? No. I'm sorry.
My adversary made a late filing last night. I would like to submit it.
Okay, I'll give you 2 minutes. People versus Henderson, appellant. I'm sorry, what? Respondent? 5, 1, and 5. Aris versus BU Realty.
Appellant 5 and 2, Your Honor. Respondent 4 and 1.
5 and 1 for appellant, 4 and 1 for respondent. People versus Felix Sosa. Submitted. Belair and Evans versus Rizzo, appellant.
Appellant 6 and 2, Your Honor. Respondent 6 and 1.
Okay, 5 and 1 for appellant and 5 for respondent. Telemann Holding versus VCW Associates, appellant.
Appellant, Your Honor, 7 and
Respondent? 5, 1, and 5. Casella Construction versus 322 East 93rd, appellant? Respondent? 5, 1, and 5. People versus Alvarez, appellant? Respondent? I'll give you 3, 1, and 3. Phone Administrative Services, I know there are 3 appellants.
Yes, Your Honor, for the appellants, for the joint argument, all appellants request 10 and 2 for rebuttal, and then for Ms. Jones for the individual defendants, additional 2 minutes.
Okay, just, so you're not doing it as 3 separate appellant arguments, you're doing it as a joint and then as one separate?
Correct.
Okay. And respondent? Okay, I'm going to do, I'm sorry, just tell me again, what did you ask for each of the arguments for the joint and then for the separate?
Joint 10 plus 2 on rebuttal, and then 2 minutes only on the opening for the individual.
Okay, so I'll give you 8 and 2 for the general. I will give you 2 for the specific one, and then I will give 6 for the respondent.
And Your Honor, on some administrative services, Ms. Jones is appearing for FHA and asking for her permission to participate in this appeal.
I'm sorry, but as one of the 8 or the 2 minutes?
As the 2 minutes.
Okay, the application is granted.
And Your Honor, this is Gregory Skidmore, also here for FHA.
Okay, the application is granted for that also. And I will be recused on that matter. Rosenblum versus Trinity Hudson, appellant. I know there are 2 appellants. Okay, and is the other appellant arguing separately? Okay, respondent? Okay, it's 5 and 1 for appellant and 5 for respondent. Donian versus NIO, appellant?
Good afternoon, Your Honor. I'll request 6 and 3.
Respondent?
Good afternoon, Your Honor. Respondent request 6 minutes.
I'm going to give you 5, 1, and 5. Fuchs versus Rakia Associates, appellant? Respondent? 5, 1, and 5. And again, if we need more time, we'll keep questioning you. So that's for you, but if we need to ask more questions, we will do so. So that would be fine. Okay. People versus Nigel Clark.
Good afternoon. Lauren Glasby, legal intern with the Office of the Appellate Defender. On behalf of my client, Nigel Clark, may it please the court. The sentence in this case should be reduced in the interest of justice because Nigel Clark was a child who was neglected by his drug-addicted mother and abandoned by his father, who was shot and stabbed by gang members, who had unresolved mental health issues, and witnessed his brother die in his arms, all before he was 15 years old. And the events only make sense in that context. He was then moved into a gang-controlled housing project with no other support or authority figure other than the gang when he was living in New York. Given that he had no support or authority figure in his life, and the fact that he was a child, it is not surprising, if not inevitable, that he joined the gang and participated in the events that transpired. The fact that there were 2 indictments, we recognize that. However, the second indictment similarly also only makes sense given this context, given the abandonment of his family and the lack of authority figures in his youth. If we look at social science and Supreme Court precedent, That would suggest that a child with a similar history of trauma and a similar background would be at high risk for gang indictment, and would be highly at risk to make similar
How should
mistakes.
your argument be affected by the fact that this second incident happened when he was on parole for the first and was let out and then committed an extremely serious incident? So how does that affect your argument? Isn't this really a case where the court considered all the factors, considering how this occurred, and the sentence was reasonable under those circumstances?
Yes, Your Honor. So the sentencing court, did have this evidence in front of them. However, the sentencing court was quite frankly wrong about the mitigation in this case. With the second indictment, Nigel had moved to California to escape the constant violence in his life in New York City, and then he was returned back into the same gang-controlled and dangerous environment that he'd been in before. His actions only make sense in that context. This was a product of his circumstances and environment.
Thank you. You'll have a minute for rebuttal.
Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. This court should affirm defendant's sentence, which was...
Counsel, with regards to the waiver of right to appeal here, it appears that you're not really contesting its validity or invalidity, right?
There is evidence in the record that defendant waived his right to appeal and also signed a written waiver. However, there's uncertainty with our ability to find that, and so we're not taking a position on the validity of the waiver. There's just a few factors I'd like to highlight for this court. Despite defendant's relatively young age, these were not impulsive decisions that he made. They were both calculated shootings that took place a year apart from each other. The 2015 shooting was planned ahead of time, and defendant participated in that planning. And the 2016 shooting was also planned. Defendant prepared an escape route before firing at two individuals and then exited through that prepared escape route. There's also no indication that defendant has shown remorse for these incidents, seemingly celebrated the 2015 shooting on Facebook after it occurred. The 2016...
Isn't that consistent with his being very young and not understanding the seriousness of it?
I would just argue that it shows a lack of understanding, and even as late as the PRS, he in fact claimed that he didn't commit the crime at all and didn't seem to understand that he had actually done these things. The 2016 shooting also took place more than a year after the first, and 3 days after he was indicted in this first case.
Counsel, isn't your adversary's argument that when the defendant was removed from these circumstances, when he went to California, he progressed, in fact, to the point where he was accepted by 2 colleges over there? How does that factor into the calculus?
I would point to the timing of this, Your Honor. The first shooting occurred in late June of 2015. Defendant left for California sometime in the summer of 2015. I don't have the exact date, but the timing of that suggests that he actually was leaving the state because of what had just occurred. He was present at a gang shooting and then was brought back almost more than a year later, and 3 days after being indicted in the first case, committed more shootings. So our position is that that does not indicate that he was progressing simply by leaving the state. Unless there are any other questions, we ask that you affirm.
Thank you very much.
Thank you.
Thank you, Your Honor. So I would just like to point out that Nigel did not, in fact, plan the shooting in the first indictment. He was merely present at the scene, and his Facebook messages just seemed to indicate that he was confirming information with others. Further, as you pointed out, in terms of remorse, yes, he was young and he maybe said something he shouldn't have said, but that does not justify a sentence of over a decade for someone who didn't harm anyone and didn't fully understand the consequences of his actions. And then finally—
What evidence is there that he didn't understand the consequences of his actions?
In the Second, the fact that he, was so young at the time, and
I understand he was young, but what evidence is there that he didn't understand the consequences of his acts?
yes, yeah, that's a good question. I think, there's not evidence necessarily in the record. It is a pretty limited record. I think just given his youth, it's the social science and Supreme Court precedents of youth sentencing suggests that someone at such a young age wouldn't have a full understanding.
Thank you very much.
Thank you.
Harmon Agency versus Wilhelmina Licensing.
Good afternoon, Your Honors. Robert Hampton Associates. I don't have much to say because in the court below, it was extraordinary that summary judgment was granted, although there was a verified complaint, about 20 pages.
Counsel, we routinely grant or allow the granting of summary judgment without discovery when it's appropriate under the circumstances. And in order to oppose a grant of summary judgment based on lack of discovery, you have the burden to specifically come forward with what evidence you would obtain from this discovery that you need to oppose the motion. And what have you come up with in this particular case?
Well, it's relatively simple, Your Honor. First of all, we submitted on the papers that there was a question of fact. It took the trial judge 17 months to make a decision on a case where there was like zero discovery, no preliminary conference, and the papers...
Well, the length of the time that the judge takes to issue a decision does not really, it's not concrete argument for why there's an issue of fact. You have to identify what the issue of fact is.
Okay, well, quite simply, I know Your Honors have read everything. In the appendix, which has everything, it's very clear that the judge applied the wrong law to the summary judgment because she used the defamation standard when in fact it was a breach of contract standard. There's absolutely no question that the termination agreement, the license agreement, provided no disparagement. Our client submitted tremendous evidence that there was disparagement. And
What evidence
Right,
did you submit?
Well,
What
there's
evidence did you submit of disparagement other than allegations? Because it's a summary judgment motion. It's not a motion to dismiss. So you need evidence, not just an allegation.
Well, no, what I'm saying, in opposition to the motion for summary judgment, we submitted information that there were like about 150 former models with this young lady whom, when they called up the number, which was owned by Wilhelmina, they said they have no information.
No,
They
wait,
don't know
other
who
than
this is.
your counsel, other than your client's statement that that's what she thought happened, right? What competent evidence do you have that there was disparagement? Let's start with that, right? Did you put in any affidavits from any of the 150 models?
No, we didn't get
Put
affidavits
in
from them.
anyone, any actual facts other than an allegation in the complaint that would support that claim?
Well, Your Honor, frankly, there wasn't a motion to dismiss. There was an
I'm just
answer
asking
file.
you what facts you put in.
Okay. Your Honor, there was discovery, and it was never answered by the defendants. We should have had an opportunity.
You
to take
don't
some
need anything
depositions.
from the defendants to support that claim. It is your claim that other people heard disparaging statements. You could have gone to those other people, right? Did you put in any affidavits from any of them?
No, the models wouldn't cooperate. But again, there should have
You
been.
can have 2 minutes for rebuttal. Thank you very much.
Thank you.
Good afternoon, Your Honors. Brett R. Schwartz, Lebensfeld, Sharon, and Schwartz for the respondents, Wilhelmina Licensing LLC, Wilhelmina International Inc., and William Wackerman. Your Honors, based on the questioning, I think that this panel has a good grasp of this appeal and why the lower court was correct in granting summary judgment. There's no credible evidence that has been presented by this appellant in support of any allegation that she has made, nor has any showing been made that there is any evidence in the possession of the respondents that would aid her in presenting her claim before this court or before the lower court. The court did not impose any improper standard regarding defamation. The court noted that they had made an allegation which seemingly was for defamation, though it was not pled by them, and the court applied breach of contract
Well, counsel,
standards.
wouldn't you say that if there's a non-disparagement clause in the release, that you can plead a claim for breach of contract if you disparage?
Yes, Your Honor.
Okay,
However,
so I'm not sure what your point is about defamation.
what
It's
the
a, it's a
point?
breach of the contract for disparagement, right?
No, Your Honor, they did not allege a cause of action for breach of the license termination agreement. They actually pled a cause of action for breach of the licensing agreement,
Right.
which was settled pursuant to the license termination agreement nearly 6 years ago, which was a bargained for exchange settlement, which my client relied on, bargained for. Both sides were represented by counsel of their own choice, and other than...
So is it your argument that she can't argue that she was coerced into signing that agreement and yet also seek the benefits of that agreement?
100% correct, Your Honor. She did get the benefit of the agreement, and she cannot now be heard to complain, nor should she be able to allege a cause of action for rescission when she relied on that consideration that she received for 2 years, et cetera. Unless the court has any further questions, we respectfully request that this court affirm the lower court's decision in its entirety.
Thank you very much.
Thank you, Your Honors.
Your Honors, the underlying facts, it's undisputed that this woman suffered. She did nothing wrong to have her license with Wilhelmina terminated. She was a phone call from somebody who threatened her because he didn't like the way she was acting. She filed a police report. The police interviewed the person. He basically apologized. There's no question there. She received no benefit to this, absolutely no benefit, except she was threatened to be sued for $50 million or something. She was scared. She signed something. But there's also the breach of contract. They signed a license agreement. They said that it was terminated. There was no initial notice of it, number one. Number two, they didn't live up to it. They admit in their papers that there was disparagement, but they say the disparagement was before the termination, okay? Before everything was wrapped up. But that becomes a question of fact. They can't just put a timing on a termination, okay, or a disparagement, but that the breach of contract should stay. Forget the disparagement. There's the question of the breach of contract. And again, I would urge you, I know you're very busy, that's why I don't want to take too much time, but if you look at the record, there's like 3 affidavits, there's a counter statement of facts. The lower court judge ignored the entire counter statement of facts.
Well, was the counter statement of facts sworn to?
No, but neither was the
So then, why should a court look at an unsworn to, which is counter statement of facts, which doesn't, 1, have any evidentiary value, or 2, comply with its own rules?
Well, the defendants was not sworn to either, and again, that's not an
And the court said
absolute
it didn't
law. It's
look at either
discretionary.
one, right?
Excuse me?
Didn't look at either one, correct? Because they were both unsworn.
Okay, but again, Your Honors, you're smarter than me. It's discretionary. It's not an absolute bar.
But
I would-
isn't what the rules require a joint statement, which they didn't follow, and that's why the court disregarded it?
Is that a reason to punish the plaintiff? You know, there could be some discovery. There was no discovery whatsoever. And in fact, we sent discovery at the very beginning of the case, and it wasn't answered. The defendants, a major international company, had already prepared their motion for summary judgment.
Thank you very much.
Thank you.
No.
Thank you. Glad I could get dressed up today.
Clark versus Fifth Avenue Development. Go ahead.
May it please the court. A fraud in New York is committed if a party to a transaction fails to disclose material information that it knows the counterparty does not have access to and cannot discuss.
Let me ask you, counsel, it's fairly well established in New York that there is no fiduciary duty to disclose between a landlord and a tenant in that type of relationship. And I understand you're relying on the superior knowledge doctrine. Has that ever been applied? Have you found any cases that have ever applied the superior knowledge doctrine in a situation having to do with lack of elevator service?
That's a little precise, Judge, but we certainly
That's
have
my
found.
question.
Yeah, we certainly have found cases where the superior
I
knowledge.
ask that because there are a number of cases having to do with lack of elevator service, and that argument has never been made in the context of those cases. That's why I'm asking the question.
There's no case, I agree, Your Honor, there's no case from this court in which a court has decided one way or another that the superior knowledge doctrine applies in a case involving elevators.
Counsel, is it your position that the landlord made a misrepresentation about the elevator?
Yes?
An affirmative misrepresentation?
Yes,
In
through
what way?
conduct. Well, two ways. One that the website for the building advertises that it has elevator service, and two, that when the Clarks
I'm
went,
talking about specifically to your client.
yeah, when the Clarks
What
went,
affirmative misrepresentation are you saying that the landlord made?
when the Clarks went to look at the building, they were told and escorted to the apartment using the elevator, which was.
No. What affirmative
No,
misrepresentation?
not in words, Your Honor.
None, okay. Did your client say anything to the landlord about their special need for the elevator?
No, Your Honor, because
Did they say, my client has gout and can't get up the stairs if the elevator goes out, or anything that you've alleged?
No, Your Honor.
Okay.
Because if you're told that on the website that the building has an elevator, and it's on the top floor of the building, and you're shown the apartment using the elevator, you have no reason to think that the elevator is suddenly going to be out of service for 2 months, when that would be an obvious breach, among other things.
Let me ask you something. Even if we assume that the superior knowledge doctrine applies,
Yes, Your Honor.
one of the things you're moving for summary judgment here.
Yes, Your Honor.
So one of the things you have to show is that there was a fraudulent intent as a matter of law. How would you show that?
Well,
As opposed to, normally it's a question of fact whether there's an intent to commit fraud.
it is a question of fact, Judge, and this is a motion for summary judgment, and the undisputed facts are as follows. First of all, the contract with the elevator repair company was signed in November of 1999, when the lease here was signed in May of 2020. The elevator
That actually undercuts your argument, doesn't it?
No, Your
The
Honor.
fact that the contract was signed 6 months before means that, or one possible explanation of that is that the landlord didn't know when it was going to do this work, especially because.
Work had already
excuse
begun,
me,
Your Honor.
Because COVID had.
No, the work had already begun.
Excuse me. COVID had also begun, so isn't it quite likely that the
COVID
landlord
had not begun when the
excuse me.
contract was signed, Judge.
It would really be helpful if you wouldn't interrupt. So isn't it the case that at that time, the elevator work didn't actually begin until July, 2 months after they signed it? Isn't it likely that in May, the landlord didn't know exactly when the work would be done?
I don't mean to be disrespectful, Judge. You're simply misunderstanding the record. If I could elaborate, I'd like to. The contract, I don't know that it's that funny, Judge. The contract is signed in November of 1999. The elevator company testified that they began work among themselves in January of 2020.
What does work among themselves mean?
Means that the construction had not begun on the particular bank. There are 3 banks in the building, and the bank on which the apartment in question was located had not begun on that bank, but the contract was to repair all 3 elevators in the building, and the work had begun according to the Guardsman Elevator Company deposition testimony in January of 2020, 5 or 6 months before the lease was signed. The work was suspended when Governor Cuomo suspended construction work, but the undisputed evidence is that they were ready to start again once the ban was lifted, which.
Thank you. You'll have time for rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Robert Dashow for the respondents. First of all, I'd like to address the issue of duty. This court in Dembeck and other decisions has said, on all square fours, there is no duty on the landlord to disclose, including the intent or plan or possibility or probability of removing the elevators from service. The Dembeck case is squarely on all points on this. There is no fraud. There is also no basis to rescind the lease. The clock...
Is my memory correct that your client offered the tenants an identical apartment on the second floor to use during the duration of the elevator being out of service?
That is absolutely correct. What is not absolutely correct is that the elevator work had not begun when counsel says it had begun. There's nothing in the record to suggest that the elevator work had been, that the actual work on the elevator had begun. As the record states, and as Your Honors have suggested, when the contract was signed, it was before the pandemic. When the pandemic hit, everything stopped, including especially construction. And there's no way of knowing, guessing when or if we'd ever be able to do any construction or renovation of this type. And if so, how far into the future? And so, at a minimum, Your Honors, summary judgment was properly denied for issues of fact. Now, what I would suggest, as I mentioned in my brief, this court has the authority to search the record.
But counsel, you didn't make a cross appeal, correct?
I did not, that's correct.
So why should we even think about searching the record in that circumstance?
In the interest of judicial efficiency and economy at this point, the court does have the authority to do it. The record shows that there was no fraud. The record shows that...
You didn't even move for that down below, though. Is that correct?
That is correct.
Okay.
Your Honors, if Your Honors have no further questions, I have nothing further.
Thank you very much.
Thank you.
With respect to your Honor's request for specific cases, I would ask the court to consider the Scharf case, the VR Optics case, the Madison Apparel case, and the Vladeck case. I don't think...
So, counsel, how do you distinguish Dembeck and...
As we say in the brief, Judge...
Sahara and NYCTL 1991 Trust, like the 5 or 6 cases where we've already said something different?
Your Honor, there's only one case that the appellant is citing for the proposition that the superior knowledge doctrine does not apply here, and that's Dembeck. In the Dembeck opinion, there is the word superior knowledge do not appear, and there is no analysis of the doctrine.
But that doctrine was available to everybody at that time, right? This isn't a new doctrine that just came up last year.
It's 100 years old, Judge. It's been the law in this state for over a century, and several cases, which we cite in our briefs, decided after Dembeck, invoke the superior knowledge doctrine and distinguish Dembeck for exactly the point I'm making, namely that it is not discussed in that opinion, and we cite those cases for your Honor. Thank you, Your Honor.
The next case is Ugo Alum versus New York State DMV.
Good afternoon. May it please the court, Dennis Fan on behalf of the state of New York. Regardless whether the plaintiffs here style their challenge to their driving fines and driving suspensions as a putative class action or as a declaratory judgment action, a 4-month statute of limitations applies, and compensatory damages can only be brought only be sought in the Court of Claims pursuant to the Court of Claims Act.
What's your response to the argument that when constitutional claims are asserted or there's an action for declaratory relief, that the 4-month statute shouldn't apply?
So there's 2 cases that I want to point your honors to. I think, first of all, Butler and this court is exactly on point. There was a due process objection to the state's statewide tax offset program,
And this court held that even that sort of constitutional programmatic objection could still be brought through an Article 78 type of proceeding, and therefore a 4-month statute of limitations applies. The same was true in Solnick, where the Court of Appeals said because there was even though there was a due process objection to the type of notice that was provided, that case said that, we don't let litigants essentially evade the 4-month statute of limitations. And there's great reasons to have that 4-month statute of limitations. The entire point of it is for agencies to be able to redo their work if they are in fact committing errors repeatedly. And so that's why we have this sort of 4-month statute of limitations, to make sure that we have an efficient process. And these plaintiffs simply did not bring their claims at all within the 4-month limitations period. So I don't think you need to look any further than Butler again. And Butler also takes care of the putative class action point. That case was similarly a putative class action. That case also sought monetary relief. And this court said, well, the gravamen of the complaint is still a challenge to agency action. What you're challenging is the state's application of a statutory program. And that is, in essence, an Article 78 type of challenge where we'll apply a 4-month limitations period to that. And I just want to briefly mention that piece about compensatory or monetary relief. Of course, the state has not waived sovereign immunity as an entity or for its agencies with regard to monetary relief, and much of the monetary relief sought, some of it's difficult to pin down precisely what plaintiffs are saying, but they, for example, in their complaint say they want compensatory damages for the time that they weren't able to spend with their family because of, the suspension of their driving license. That's not incidental to the suspension of your driving license. That's really the sort of consequential damages that are only available if you properly bring a case in the court of claims. The last thing I'll say just is, you don't need to reach the merits of this case, of course, if you rule on the statute of limitations issue. We think that issue is sufficiently clear, but at least just on the merits, the only thing that I'm going to say about that is there is an address of record that DMV has. They ask people to change that within 10 days if they decide to move out of state. The plaintiffs here simply didn't change their address of record. There's an accepted process for doing that, to change your official address of record, and that address is associated with things like your voting record. So that's why it's so important that we have individuals actually change their address.
So, counsel, when the plaintiffs in this case provided the officers with their new updated address when they got the subsequent tickets or violations, that's not enough? Put the DMV on notice that they have a new address?
That's not enough, Your Honor. I just want to give you kind of 2 examples of classes of people and why the DMV can't just assume that whatever is on your ticket is your new address. You have all sorts of, for example, New Yorkers who are out-of-state college students now, and they might still want their mailing address and their official address to be their home address. You have all sorts of New Yorkers who are snowbirds, who have a home in Florida or in California. And what they want is to have their New York address be their most secure address and be their mailing address. And the DMV simply can't be reading people's minds about what address is actually their real address. And in fact, if DMV switched addresses, we'd be getting a lawsuit from the other side saying that, well, you didn't use my official address of record, that was my voting address, you used this other ticket address. And we'd have this same exact lawsuit and the same exact problems. That's why we know that this is a reasonable choice that DMV made to stick with the statutory official.
How do you respond to the lower court's ruling that that provision requiring the change of address within 10 days doesn't apply to the plaintiffs here?
That's not correct, Your Honor. It's, of course, a statute, and I'll just briefly wrap up. It's a statute that says anyone who changes address and goes out of state, and these plaintiffs were indisputably in-state residents that left the state, and that's Section 505, subsection 5, I believe. And it says you can change your address, and there's a specific form on the DMV website, like MV232 or something along those lines. Thank you.
Thank you very much.
Good afternoon, Your Honors. My name is Gregory Frank from Frank LLP. I'm representing the appellees in this action. I can jump ahead to some of the things that my opposing counsel mentioned, but I think that the court really grasped what's going on here with its first question concerning the constitutional due process element of this case. That
Counsel, though, the cases cited by opposing counsel, which explicitly allow constitutional claims to be brought in the context of an Article 78 proceeding. We have a number of those kind of cases in the First Department.
Yes, Your Honor, but none of those cases involved circumstances such as these, whereby there was a allegation of a constitutional denial of due process of notice. And the reason that this is important is that the 4-month limitations period in an Article 78 hearing assumes that there is more than sufficient notice, because the purpose of Article 78 is to address rules that have gone through a rulemaking process. And so there's no assumption and no possibility that affected parties will not have received notice due to a failure of the state. And so all of the cases—
Isn't the gravamen of your claim that the state acted improperly and not on a rational basis in the way that they're providing notice about these fines?
Yes, Your Honor, and in that
Why
respect—
isn't that then an Article 78 proceeding based on the rule that you look to the gravamen of the action in deciding what the appropriate statute of limitations is?
As the Lax case holds in a nearly identical circumstance, where the question is the agency's negligent failure to observe procedures that cause the harm, an Article 78 case is not appropriate. And the Lax case really delves into this question in a detailed manner. I hope that the court will follow Lax on that.
Thank you very much.
Thank you.
Your Honors, just one very quick response. The fact that this is a lack of notice case doesn't get you out of the statute of limitations period. At best, what we have here is a case where the plaintiffs actually did have notice. It wasn't just reasonable notice, but they actually had notice because one of them paid their fine and the other learned from their parents. That's Plaintiff Berkowitz learned from his parents that, in fact, his driver's license was suspended, and they still brought suit 4 months later. Just because you have a lack of notice doesn't mean your statute of limitations period gets tolled indefinitely or that the clock never starts running. At a bare minimum, it has to start running once you actually learn about the agency action that you're aggrieved by.
Thank you very much.
Thank you, Your Honors.
Singh versus New York City Housing Authority.
Your Honor, if I may just make sure that the court is denying me the additional 2 minutes and didn't just miss that I requested it.
I'm sorry, what?
I've requested a reserved 2 minutes. I don't know if—
You don't get rebuttal time.
Oh, I'm sorry, Your Honor, I made a mistake.
So I understand you to just be asking for 2 minutes because there's no rebuttal time for—
Oh, of course, I'm sorry, Your Honor, I made a mistake. Thank you, Your Honor.
Good afternoon, and may it please the court. My name is Denise Rubin. I'm with Subin Associates, and I appear here today for the appellant plaintiff, Mr. Singh. Primarily, we are concerned with a finding by the Supreme Court that said there was a question of fact about whether or not this accident even occurred. That is a settled matter. It was found by the Workers' Comp Board in an order—
Did you put any of the work— oh, I'm sorry, go ahead.
Sorry?
Did you put any of that Workers' Comp Board information before the lower court?
His testimony in 7 places said he was getting workers' comp benefits for this
Okay,
accident.
but I mean, that could mean anything. What is
Your
it that you're saying? The fact that he said, I'm getting workers' comp, put the court on notice that this was an accident that was covered under 241(6)?
No, the question is whether an accident occurred. That's what the Supreme Court said, not whether it was a 241(6) accident, not whether it was a 240 accident. She said there were multiple questions of fact
And wasn't
Not
that a
the least
reasonable?
being, I'm sorry.
Wasn't the question of whether or not an accident occurred a reasonable inference from Malpreet Singh's affidavit?
Again, no, not where the workers' comp board said otherwise.
But you didn't, excuse me, I don't think I heard an answer to Justice Scarpulla's question. You didn't submit in the record the actual award from workers' comp, correct?
Correct, but there was no rebuttal offered to his testimony, and you don't get workers' comp benefits without a finding by the workers' comp board that you're entitled to them. Nobody said otherwise.
Counsel, even if that's all true, the workers' comp did not make any finding that there was an elevation-related risk or that there was a violation. So how can it affect your 240 or 241-6 claim, even if we accepted that there was a collateral estoppel effect, because it's not the same issue?
Again, it's not the question of whether it was covered under.
So I'm having trouble with the clock. If you have 2 more minutes.
Yeah,
I'm telling you I have trouble with the clock. That's why the red light went out, but you have 2 more minutes.
Oh, I do.
Just explaining.
Yeah, the question on this appeal is not even whether the labor law covers his damages here. The question is, did he fall anywhere on this job site?
The question is whether you're entitled to summary judgment on your 240 and 241-6 claim. Part of one of the elements for both of those claims is to show a violation of 240 and 241-6. And you're saying, oh yeah, I have the workers' comp, and that's enough to make me win the case.
Right.
I'm saying, how can it be enough, even if we get over all the other issues with it, when it doesn't make any finding as to those issues?
Because, Your Honor, the Supreme Court did not say there's a question of fact as to whether this ladder was defective or whether he didn't have proper safety devices. The court said there's a question of fact whether he was hurt, whether an accident occurred of any kind. That very simple question, did an accident occur, is not a question of fact. It's been resolved by the Workers' Comp Board. And they take the Workers' Comp Law Section 20, as we cite in the brief, is final as to all questions of fact and except as provided on the appellate section, Section 23, as to all questions of law. Now, this was a question of law, we're not asserting new facts, we're not asserting new law. We're saying, did he fall? Was there an accident?
Okay, I'm just going to say thank you. You have time on rebuttal.
Thank you, Judge.
Good afternoon, Your Honors. May it please the Court, Matthew Lavoie of Newman Myers for Respondent NYCHA. Appellant didn't address this today.
Counsel, can I ask you, can we take the lower court's decision to mean there is a question of fact as to whether or not the accident occurred the way that the plaintiff said it occurred?
That's how I understand it, Your Honor. I mean, the plaintiff has testimony specifically saying that his foreperson or his supervisor, Malkeet Singh, saw him fall, that Malkeet Singh came to his aid, gave him water after his fall, that he let him leave work early that day. Malkeet Singh's sworn testimony rebuts every one of those allegations.
And is there anything in the record from the workers' comp board finding that would lead one to be able to decide as a matter of law how the accident occurred?
Not at all, Your Honor. In fact, the Workers' Compensation Board decisions aren't in the record, period.
Again, you have time. I'm having trouble with the clock. I'm trying to get someone to help me fix it.
Yes.
I'll keep track of your time.
Appellants didn't provide the workers' comp decisions to the court below. They're not anywhere in the record. Accordingly, these decisions don't appear on the face of the record. Appellant is trying to inject new facts at the appellate level with these Workers' Comp Board decisions. Unless Your Honors have any further questions, I request that this court affirm.
Thank you very much.
Thank you.
May it please the Court, Your Honors. Michael Gleason for the respondent, Lero. Lero is in a very different situation than the other defendants in this action. It's the construction manager of the project. One of the main issues with plaintiff's request for summary judgment under 241-6 against Lero is that plaintiff attempts to lump everyone into one situation. They're not. A construction manager, as Walls v. Turner Construction held, they're only liable, or a construction manager is not responsible for injuries under Labor Law 241 or 241-6 unless the construction manager has the ability to control the activity that brought about the injury.
So if there was a question with respect to how the accident occurred, would that affect a summary judgment finding against your client?
As it was denied?
Or if there's an issue of fact, does that affect a 241? Plaintiff saying, grant me summary judgment on my 241, 240 claims. If there's a question of fact as to how the accident occurred, not with respect to whether there was an accident, does that affect whether or not the court should grant summary judgment in plaintiff's favor?
The court should not grant summary judgment in plaintiff's favor as against Lero in particular, as they never addressed that standard as laid out in Walls v. Turner Construction. It was raised below, they never mentioned it. In the brief in support, it was never mentioned. I dedicated 30 pages of my brief in opposition to it. It was never even addressed in reply. It cannot be said that plaintiff met their prima facie burden establishing control of the injury-producing work as against Lero. And one final point, all the other...
Thank you. Your time is up. Thank you very much.
Good afternoon, Your Honors. John Gorton for Gorton & Gorton for Respondent Superstars. I think the court has hit upon the central issue in this appeal. Plaintiff below didn't move for summary judgment saying, all I want this court to say is that I had an accident on the job site. I'm not moving for 240. I'm not moving under 241-6. Literally, all I want the court to say is that somehow, somewhere on this job site, I somehow was injured. Well, that's not what they moved for. They moved for summary judgment under the labor law. And the court below said, I have an affidavit from someone who literally stars in plaintiff's scenario of how this accident occurred. This is not a scenario where the plaintiff comes in and says it was an unwitnessed accident. He has Malkeet Singh at every single portion of this accident, leading up to it, witnessing it, and then ultimately after it. He still has Malkeet Singh there. And an affidavit properly placed before the court by Malkeet Singh denied all of that. And I respectfully submit that a jury is not going to be able to reconcile Malkeet Singh's affidavit and plaintiff's version of this accident. And if they accept Malkeet Singh's version, under falsus in uno, plaintiff will be thrown out of court because the jury is then allowed to reject all of his testimony. To me, when you read the record, there is no clearer question of fact as between Malkeet Singh's affidavit and the plaintiff's affidavit. And essentially what the court decided was the motion in front of it, which is that the plaintiff did not carry their burden to establish as a matter of law that there was no legitimate question of fact regarding a violation of 240 and 241-6. That was the issue before it. That's the issue that the court decided. And respectfully, that's a decision the court should affirm.
Thank you very much.
Thank you. Counsel, in your first part of your argument, if I didn't have the decision in front of me, I would have thought that the motion court simply decided that no accident occurred. But in fact, what the motion court said is, movement has failed to establish entitlement to summary judgment as a matter of law as there remain issues of fact, including but not limited to whether the accident occurred. So, and that came after a recital of what the plaintiff said and what Malkeet Singh said. Right. So I don't, it seems to me that that was one issue of fact, but that the court also said there were other issues of fact. So I don't see that that would have been solved by the workers' comp decision, even if it were in the record, which it's not.
Respectfully, Judge, the court didn't identify a single other. There was a statement, there were multiple questions of fact, but did not identify any others except for whether an accident occurred. Now, if that was reversed, if whether an accident occurred is reversed by this court because the collateral estoppel issue certainly binds superstars.
Well, counsel, I'm
and
glad you
Malcolm
brought
Singh.
that up.
Sorry?
I said I'm glad you brought that up about the collateral estoppel because that was something that you didn't raise below. And I'm talking about the workers' compensation issue. So how can we even review that when you didn't raise it below with respect to the workers' compensation?
Because this court has repeatedly held that an issue purely of law can be raised for the first time on appeal if it does not assert new facts.
I agree with you.
Or new
However,
injuries.
that's not what we have here because my colleague asked earlier, what, if any, documents did you provide as it related to the workers' compensation decision to talk about how the accident happened, et cetera, et cetera? And I believe that your answer was no. So how is it a question of law when we have to look outside of the record?
Because the fact is established by the unrebutted testimony. And under this court's holding in Kuhn and Nagel versus Baden, the unrebutted testimony can be deemed admitted if nobody has come forward with proof that says he isn't getting workers' comp for this injury, then that's an admitted fact, aside from the collateral estoppel issue. And we're the only person who alleges...
Thank you.
Sorry.
Your time's up, and you've answered the question.
May I just finish the sentence?
Go ahead.
We're the only person who purports to question this fact, to offer evidence, is bound as an employee of Superstars by those orders, even if this court doesn't find that there's privity as to the other defendants, which I would argue there is.
Very long sentence, counsel.
It is, but...
Thank you.
Thank you.
PA infant.
Good afternoon, Your Honors. May it please the Court, Gina Bernardi DeFalco from McAloon and Friedman, on behalf of New York Presbyterian Hospital and 3 physician defendants named in this case. I understand my adversary is not here. I don't want to take up too much time. But late last night at 8:30, he filed a reply brief. And I wanted to make a formal application that that be stricken and not considered, given that I had no opportunity to review it and digest the cases.
I'm not aware of it, but we would not consider it.
Okay, I appreciate that.
I'm not even aware of its existence, but if it was brought to us, we would not give it any consideration.
I thought that might be the case, but I figured since I'm here, let me bring it up. The second point I just want to make very quickly is I just want to underscore how important an affirmance is in this case to the entire maintenance of the child protective system. I have 3 physicians in this case who were caught in an unenviable position of a mother reporting symptoms that they're not seeing, of a father calling up saying, I don't want my child having this surgery, I'm concerned this woman is exaggerating, and then having to be dragged through court.
We understand that the standard is very lenient towards doctors in this situation. It's, a reasonable suspicion in that, as long as there's any basis, that no basis for liability.
Thank you. And I think that's clear from the complaint, that there was a reasonable basis here and the immunity needs to stand. Thank you very much, Your Honor.
Thank you very much. The next case is People versus Henderson.
Tell. I understood.
Good afternoon, Your Honors. May it please the Court, Cameron Johnston from the Office of the Appellate Defender for Mr. Paul Henderson. Paul Henderson took a mug from Starbucks and fled. This is shoplifting, but his conviction for third-degree robbery turned entirely on the dubious testimony of a single witness, Roger Vargas, who was not credible. Mr. Henderson's conviction should now be reversed and the indictment dismissed because it was against the weight of the evidence.
Counsel, you want to focus on weight of the evidence and not the Sandoval?
Whatever Your Honor would prefer.
Why don't you focus on the Sandoval argument?
Okay, I'm happy to do that. And to be clear, this issue was not preserved by defense counsel. However, we're asking this court to address it in the interest of justice. And so because Mr. Henderson and Mr. Vargas were in this credibility contest, as I mentioned, the Sandoval modification prejudiced his right to a fair trial. So first, Mr. Henderson did not open the door. When asked on cross-examination, isn't it true that you have 3 felony convictions, Mr. Henderson answered unambiguously and completely forthright that he said, yeah, I guess so. We would have to completely reject colloquial speech to come to the conclusion that answering, yeah, I guess so, is not an affirmative yes to that answer. So,
Wasn't it a little more than that, though? Wasn't it something like, I'm not sure?
no, Your Honor. Potentially, if it was, I guess so. But Mr. Henderson initially said, yeah, I guess so. And, you know, to any contrived extent that that can be interpreted beyond an affirmative answer, then it's equivocal at worst, which...
Well, counsel, before that, on direct examination, the defendant was asked if he had any convictions in New York State, right? And I believe his response was yes. The follow-up to that was, do you remember how many? And he said something like approximately, I guess, 2 or 3 felonies, 4 or 5 misdemeanors. That's enough, isn't it?
Is that enough for what, Your Honor?
Is there anything wrong with that statement? How do you view that? Because clearly the prosecution made an application to have the Sandoval ruling modified, to let them go into the underlying facts. Did that response justify that modification?
No, certainly not. The 2 to 3 was completely an affirmative answer. You know, in the Sandoval hearing, Mr. Henderson is required and obligated to
And counsel, let me just ask you, what effect did the modification have on the testimony?
Well, the modification was prejudicial because...
Okay. Why?
Yes, Your Honor. It was specifically prejudicial because it laid a foundation for that Mr. Henderson had a propensity for lying, that he wasn't being truthful. And this is especially important in this case in which it was truly just Roger Vargas's word against Mr. Henderson's word. And this is impermissible, you know, where it was...
Is that your argument why we should review it in the interest of justice? Because as you previously stated, it is unpreserved. So is that your interest of justice argument because it was so prejudicial in this case? We should invoke our interest of justice power to consider it?
Yes, Your Honor, and I just want to add that it was especially damaging because the court instructed the jury specifically that it could consider whether Mr. Henderson's prior convictions and conduct affected the truthfulness of his testimony. And so that put the district attorney had the opportunity to elicit the underlying facts of a forgery conviction. And a forgery conviction is known commonly as a crime of dishonesty. And so it put this light of Mr. Henderson into the minds of the jury, which was prejudicial. And if there are no other questions on the Sandoval issue, then I'm happy to address the weight of the evidence issue as well, if Your Honors are interested.
You have 10 seconds left if you want to say something.
Well, I'll address that on rebuttal.
Okay.
Thank you.
Thank you very much.
Good afternoon. May it please the court. Molly Morgan on behalf of Respondent. The trial court...
Counsel, could you address the issue that was discussed a few minutes ago as to why the defendant's response justified the trial court from deviating from what it had said its Sandoval ruling would be?
Yes, Your Honor. Well, first, I'd like to point out that even on direct examination, defendant's answers were evasive and misleading. He said he had been convicted of approximately maybe 2 or 3 felonies and maybe 4 convictions. But even beyond that, the
Counsel,
prosecutor...
how is that evading or misleading when in fact I believe the holding was that he had 3 felony convictions and he had 5 misdemeanors?
Well, Your Honor, it's our position that that's evasive because it clearly under-encompasses the extent of his criminal history. But even beyond that...
Maybe it just says that he doesn't remember.
Well, the trial court Sandoval ruling was that he had to be forthcoming and honest about the extent of his criminal history.
Well, counsel, he certainly didn't deny that he was ever convicted, correct? He didn't deny. That's a yes or a no.
No, he did not, Your Honor. However...
Okay, so, and he also did not present any facts to mislead the prosecution regarding the nature of the convictions. Am I correct about that?
Your Honor is correct that no, he wasn't misleading with respect to...
Nor did he claim innocence in any of those prior convictions, correct?
Correct, Your Honor. However, I'll note that if you do read his testimony, he does get a little bit evasive with the prosecutor with respect to...
So what you're saying is he didn't boast about his convictions. That's basically it, right? If he didn't boast about it, maybe he said approximately, but he didn't lie, and he didn't undermine, but he didn't boast. And that's your view, that you think that is what allows the trial court to modify the Sandoval hearing?
No, Your Honor, it's not the fact that he didn't boast, but
What is it? I can't figure it out. You said he told the truth. You said he didn't, deny the crimes. You said he didn't claim he was innocent. So what is it? What was it?
Your Honor, his intent to mislead and violate the Sandoval ruling was made abundantly clear when the prosecutor said, "Isn't it true that you've been convicted of 3 felonies?" All he had to do there was say yes, but then he said, "Yeah, I guess so." And
you're saying, "I guess so," as opposed to a boasting, "Sure, yes, I did," allowed the trial court to modify the Sandoval ruling?
yes, Your Honor. And I would also add that there was a bench conference that was not transcribed, so we don't know. I don't want to withhold. I don't want to put forth that anything did or didn't happen. But if that was on the record, we would know whether or not he said yes. I
just to go back. So when he says, "Yeah, I guess so," isn't that really the defendant being uncertain about the number of crimes, the number of convictions? Wouldn't you agree that that's really to say, you know what, I'm uncertain about the number, but, I'm not denying. What do you say to that?
I think it still violates the spirit of the Sandoval ruling because he knew, he must have known that he had been convicted of 3 felonies and 5 misdemeanors. If he had simply said, yes, that ends there, then he said, no, I don't know.
Why do you think he must have known that? I mean, not everybody counts everything in their life in the same way. I'm troubled by your inferring from his saying, "I guess so," that it means he was lying or prevaricating or something. Why couldn't it be that that was his best guess?
That may be, but then his intent to mislead was really made clear when he said, no, he doesn't know. And there was a Sandoval hearing, then
Counsel,
I assume...
earlier you had made some mention about a colloquy at the bench that was not transcribed. What relevance does that have? Because could whatever had been said at that colloquy, could that be the basis for reversing the Sandoval ruling as opposed to what we know was said, what the defendant said, which is on the record?
Well, Your Honor, I think it certainly could have elucidated the issues here and the court's reasoning and what exactly defendant did know and perhaps the reasoning behind those answers. But we don't know that. And
But the best information that we have before us is what the defendant actually said, which is in the record.
Yes, Your Honor, and this is unpreserved. The bench conference...
Well, let me just ask you this last question. Do you agree with counsel that this was 100% a credibility determination between these 2 people, the complaining witness and the defendant, correct?
Yes, Your Honor.
There wasn't any other, so if the jury didn't believe the complaining witness about seeing the flashing thing in the bag, the defendant would have been convicted presumably of petty larceny, as opposed to robbery, correct?
Yes, but
So that's a pretty big difference in findings based on a credibility determination, right?
Yes, Your Honor, but I would note that, you know, the complaining witness's testimony was clear and consistent throughout, that defendant had said, is this mug, this $5 mug, worth your life? And there was a flash of metal.
Counsel, isn't it true that the prosecution had some concern about what the complaining witness was going to say when it warned the court that he might need to have counsel appointed?
Well, Your Honor, I would note that, you know, the trial court did specifically say that it would shut down any testimony that was perjurious, and also.
Well, my point is that this is a credibility determination, and it appears that the people have expressed some concern about its own witness.
And those concerns were unfounded, as demonstrated by the complaining witness's testimony at trial compared to his grand jury testimony, which was also brought out. And I would also add that, you know, the Sandoval ruling, there was absolutely the most minimal prejudice because of the court's comprehensive limiting instructions. The court repeatedly said this is only to be used to determine the defendant's credibility.
Well, how is that minor if credibility is the only issue that goes to who's going to be believed?
Your Honor, the jury saw Roger Vargas on the stand. It heard about all of these credibility issues from both sides. It made the determination that Roger Vargas was threatened, and they saw him, they heard him, they believed him. Moreover, these
They
underlying
saw him
felonies-
and heard him and believed him in the context of having this additional information, which the motion court had previously said it wouldn't give them.
Well, Your Honor, his intent to mislead was clear. He said he didn't know how many felonies. The trial court told him, you have to testify truthfully that you have 3 felonies and 5 misdemeanors, and he was evasive. Moreover, the forgery conviction bears very minimal resemblance to this case. It was stealing something from a gym locker. This involved the flashing of a knife and threatening someone's life who was simply trying to reclaim this mug. Finally, with respect to the sentencing point, I would just note that defendant was released on October 20th, a few weeks ago, and parole supervision would be particularly appropriate for him in light of his criminal history. Unless the panel has other questions, we ask that you affirm.
Thank you very much.
Thank you.
I just want to make one point that there's no indication in the record that Mr. Henderson may have participated in the off-the-record conversation between counsel and the court to justify a Sandoval modification.
We don't have that as part of the record anyway for something for us to consider, so it doesn't really matter.
Okay, and additionally, there's also no basis in the record that the jury resolved the credibility contest in favor of Mr. Vargas. Instead, there is actually a strong indication that the jury didn't credit Vargas and convicted Mr. Henderson based on his own testimony by making an incorrect legal conclusion that using a curse word was a forcible threat. And this is because the jury specifically returned a note, asking questions that indicated that they were grappling with Mr. Vargas's testimony. And I see my time is up. Can I briefly conclude this thought?
Very briefly.
Okay. So specifically, they asked whether FU, the curse word that Mr. Henderson testified to using, is a threat that amounts to a forcible taking. And this, Your Honors, is an indication that the jury may not have resolved the credibility contest in favor of Mr. Vargas, but very well may have resolved that in favor of Mr. Henderson.
Thank you very much.
Thank you, Your Honors.
Aris versus BU Realty.
Good afternoon. May it please the court. Damon Howard of Efron Mandel and Howard for the appellant's plaintiffs. We seek the partial modification of the motion for summary judgment that was granted on behalf of the other plaintiffs' tenants in this action. This arises from a J51 deregulation case.
Counsel, we are familiar with the case, and we know there are many moving components and issues that have come up. I'm going to ask you about a fairly discrete, specific one to start, which is, where is the evidence in the record that Barry Strauss resided in apartment 2C?
Your Honor, it was part of the leases submitted by both sides.
Where in the record? I don't see any lease in the record that shows that Barry Strauss resided in apartment 2C during the time period that you're talking about. There is a lease in the record during that time period. It's for another person. It's not for Barry Strauss.
Your Honor, it was both the landlord's own DHCR registrations as well as the undisputed lease documents that were submitted into evidence.
You're saying that, do you have a record site for where the evidence that supports that she resided there in that period?
Yes, Your Honor. The payments in 2C are at the record at 867 and 914.
Sorry, the what?
The payments for the 2C, there were actual checks cashed for 2C. Those are at the record at 867 and 914. The DHCR registrations that refer to 2C are at the record at 257 to 295. And the lease itself, I believe, is at the record at 285.
That's not a lease for her, though.
Right, that's a
Sorry?
lease.
It's not a lease for her. That lease at page 287 is not a lease for Barry Strauss. That's why I'm asking the question specifically about that issue. It's a lease for someone else. You go look at the record.
Your Honor, then I would rely on the DHR registrations themselves, which are filed by the landlord. And
How do we deal with the fact that there's a lease for someone else for that apartment?
Your Honor, there is a long history of amended registrations that clouded the record, which is part of the fraudulent scheme here. So in 2015 and again in 2017, the landlord filed a wholesale amended registration of nearly every apartment in the building. So it
Which makes
created...
sense. It's hard to rely on those registrations, which it's hard for that to be your proof. But let's leave that aside and go to the relation back doctrine and why you think it should apply.
Sure, Your
Because it's
Honor.
rare for it to apply in these type of scenarios, so why should it apply in this case?
Your Honor, I think that in Bellini v. Garsal Realty, this court was very clear that whether or not an amended pleading should relate back for purposes of the statute of limitations is whether or not it provided notice to the other side of the underlying transaction. In this case, I would note that the facts here, the underlying facts that support the summary judgment that was granted for all the parties here relies on the landlord's own DHCR registrations and undisputed leases. There are no contentious issues of fact. There are no disputed matters. We're not combating affidavits over what happened. It was simply the legal conclusions. So they were on notice of the core issues, facts that would be relied on by those subsequent amended plaintiffs. And I would also note that even prior to the bringing of this group of lawsuits, because it is one of 9 lawsuits in the same building, that the DHCR, as well as an assemblyman for the local district, wrote to the landlord and said, you're improperly treating these folks as
You're saying there was
deregulated.
ample notice that they knew about these particular plaintiffs. Let me ask you one more question, since our time is running out. Do you want to address Arnott and why you think the court got it wrong as to him?
Yes, Your Honor.
In the context of the litigation?
We submit that on both the facts and the law, that was the incorrect conclusion by the court on the facts, because although Plaintiff Arnault moved in 2013, the court concluded that a fair market rent was appropriate for Mr. Arnault because of the fact that he was the first rent-stabilized tenant in that apartment, and that when a apartment transitions from rent control to rent stabilization, a landlord can charge a fair market rent subject to the fair market rent appeal process. However, the landlord's own sworn filings with the DHCR, sworn under penalty of law, that included a list of all of the rent control apartments in the building showed that it had not been a rent-controlled apartment for 7 years. So on the facts, it was not a rent-controlled apartment. It had not been one for 7 years. Furthermore, on the
Thank you.
law,
If you want to address it further, you have rebuttal time. Thank you.
Good afternoon, Your Honors. May it please the Court. Michael Littman for the defendants, respondents, appellants. The Court is correct with its first question this afternoon. No leases were provided for apartment 2C with Barris Strauss, and the lower court properly found so. There was no proof provided.
What about their argument about the rent registration and the payments?
While that is proof of what the landlord registered and what the tenant paid, it's not the actual contract that was allegedly entered into between the landlord and the tenant.
But isn't the landlord bound by that?
Bound by which? The
By his
registrations?
filing?
Yes, but they are self-reporting, and they're not. The tenant didn't produce the lease that they allegedly entered into for that apartment. Further, the base date for that specific plaintiff was November 15th, 2012.
So are you saying that the landlord self-reported incorrectly?
This landlord did self-report incorrectly, and when he was put on notice by the DHCR and by this local councilman, the landlord attempted to rectify the errors that he previously made, and he did register a bundle of apartments. He tried to correct his prior mistakes. The new plaintiffs that were added in 2016 on the amended complaint, they have a different base date than the.
So why do you think relation back why shouldn't relation back apply to those parties?
It should not apply because each tenant in the building has its own rent history. There was no notice of claims of other tenants in the building when the first original complaint was filed.
Counsel, there's no question that this landlord, not only is no question, it was found in another proceeding, that this landlord knew that all of the apartments in the building were subject to rent stabilization during this period, every single one. So because they knew every single apartment was, they knew that the 4 to which plaintiff is attempting to use the relation back also was subject to rent stabilization. So the undisputed record seems to indicate that they did have knowledge. So isn't that the most appropriate circumstance to use the relation back doctrine?
He may have had knowledge that it was rent stabilized, but the
And he acknowledged that he was not charging the rent stabilized rate. So why shouldn't the relation back doctrine apply?
Because each individual apartment has its own rent history, has its own leases, has its own rents.
But there's no dispute on this, is there any dispute on this record that the apartments were subject to rent stabilization and it was not charging a rent stabilized rent for any of these 4 apartments?
I don't think that's in dispute during the J51 period that
So
they were.
why is that not enough by itself to establish the appropriateness of the relation back doctrine in this case?
Because each individual tenant has its own rent history.
I don't understand what that means.
They each have their own.
Excuse me, you've said that now 3 times, and it doesn't make any more sense to me now than the first time you said it. I understand every tenant has his or her own history, but if there's a pervasive pattern of overcharging and a pervasive pattern of the landlord failing to treat apartments as rent stabilized, then we can apply that across the board as opposed to saying everybody has their own history.
Well, the statute of limitations for a rent overcharge is, it starts the date that the complaint is filed and it goes back 4 years.
Right, but the relation back doctrine modifies that where there's a consistent pattern in a building, which we certainly, do you dispute that there's a consistent pattern here?
I do, Your Honor. I don't think each apartment was treated the same way. Some of them were rent controlled that transitioned into deregulation, then back into rent stabilization. There are all different factors for each apartment.
Thank you very much.
Thank you, Your Honors.
I'm sorry, does anyone have any more questions? Thank you. You'll have time for rebuttal.
I'm sorry?
I was telling him he would have time for rebuttal, as do you.
Your Honor, Speaking back to the relation back doctrine, I would just point out that the basis for the First Department's affirmance in Chrysler v. BU Realty, which is a companion case to this case, which was unanimously affirmed, was that Mr. Bigoni had testified that he was aware of the repercussions of the receipt of J51 tax benefits and the fact that that would result in his obligation to afford the protections of rent-stabilized status to all the tenants in the building. So he testified that by...
Prior to these 4 tenants filing their complaint or after?
This would have been, he testified that he was aware in 2009 or 2011 at the latest, many years before these 4 plaintiffs brought their action. It's also before any of the litigation.
So that testimony applies to all these new plaintiffs?
Correct. He was aware that the building should be stabilized, and he failed to accord that status to his tenants.
Thank you very much.
Mr. Bigoni did testify prior to the complaint in this action that he was aware of the effect of the J51, and I just ask that the court, as the lower court did, address each individual apartment on its own. If there's no further questions, Your Honor, I ask that the court affirm in part and reverse in part. Thank you.
Thank you very much. The next case is Belair and Evans versus Rizzo.
Your Honors, before we begin, Cynthia Park for the appellant defendant. I would just like to introduce my co-counsel, John Doyle, and request that he be permitted to participate in this appeal. His pro hoc vice application was granted on October 27 this year.
Yes, he can participate. Thank you.
Thank you, Your Honors.
May it please the court. Good afternoon, Your Honors. John Doyle, Brown Rudnick for the defendant appellant, Dr. Peter Rizzo. Though this case is nearly spanned for 7 years, it boils down to one thing.
Counsel, I have a question. Where in your counterclaim do you allege causation, specifically that but for plaintiff's negligence, defendant would have prevailed at a hearing or obtained a more favorable settlement? I've read your counterclaim many times, and I couldn't find that allegation, which seems to me critical in a legal malpractice case. So could you point me to where that is?
Yes, Your Honor. And I think throughout the counterclaim as you
I don't want throughout. I want exactly where you make that allegation.
And I'm sorry, Your Honor. Your exact question is where do we...
Where you allege that but for plaintiff's negligence, defendant would have prevailed at a hearing, or if he reached a settlement before a hearing, would have obtained a more favorable settlement, but for plaintiff's negligence. Where do you allege that?
Well, Your Honor, I think if you look at page... I think if you look at paragraph 42, Your Honor, we allege the negligence and we allege...
In paragraph 42, you allege the negligence, but you don't allege, but I don't see in paragraph 42 that you allege the but for causation. That's what I'm asking you about.
Well, Your Honor, I think it's imputed into the request for damages in here as we allege throughout this entire thing that Mr. Belair's conduct, both the fraudulent conduct, the direct conduct, the negligence, however you want to look at his breach of fiduciary duties throughout this action, coerced and put Dr. Rizzo into the position where he had to take this consent agreement, and then that resulted in the damages that have occurred, which are the loss of his, first of all, they terminated him immediately.
So, counsel, is the termination letter doesn't say anything about this hearing, right?
I'm sorry, Your Honor, it doesn't say
His
anything.
termination letter doesn't say anything about the OMPH hearing. It says he was terminated because he didn't get privileges, or he didn't get a specialty,
Board
right?
certified.
Certified, that's it, I'm sorry, yes.
Yes, Your Honor, and that's a pretext. His
Okay.
termination was a pretext.
Well, is that a business document from the hospital, correct?
Yes, Your Honor.
And what, so assuming that that's competent evidence, what did you put in to just make that a factual issue?
What did we put in our brief, Your Honor?
Or
Well,
no,
Your Honor,
no,
I think
any,
that-
what, I mean, that's a document that was put in, right? There's a document. There was no claim that he was fired, your damages, because of this, because here's the document that says why he was fired. What did you put in to raise an issue of fact on that issue?
Well, Your Honor, I think that's the problem here, is that the way that the trial court maneuvered through this in a 3211A, right? We look at A1 and A7. We have a plethora of evidence.
Right, A1 is, here's a document that proves that that disproves your case 100%. So your obligation in opposition to an A1 is, no, here's a document or something that raises an issue of fact. Again, I'm going to ask you, what did you put in on that point?
Your Honor, I apologize. I'd have to go back here and take a look at the entire record.
I didn't see anything, but let me ask you one other question. Assuming that your claim for legal malpractice, taking that aside, how are your other claims different from the legal malpractice claim?
Well, Your Honor, I think when we look at we needed an opportunity to continue to develop that and ask for the permission to be able to amend the complaint. I mean, when we went through...
No, this is a 6-year-old action, right? I'm just asking you, the trial court said, and all your other claims are dismissed because they're duplicative. I'm asking you, are they duplicative?
Well, there's some, Your Honor, that may be duplicative, but there's also others that may not be.
Which ones?
The fiduciary duty, I think that we can show there's additional damages caused from the fiduciary duty. That breach of the fiduciary duty to him and his engagements with the hospital both impacted him both at the hospital with the New York Department of State, and then it would later impact him as well.
And why would those damages be different from the malpractice damages? If in fact you had alleged causation?
Well, Your Honor, I think that, again, we would have to go back and look, and we'd be able to parse out what the different damages are as a result of that. But again, I think it comes back to 6 years worth of discovery, a ton of evidence put forth with this doctor who served the New York area for over 25 years. And we had a plethora of evidence to be able to put forth. That a new judge came in, show cause order, sua sponte, to dismiss this case on documentary.
I'm familiar with the background. Thank you very much. You'll have time for rebuttal.
Good afternoon, Your Honors. May it please the Court. Aaron Barham with Furman, Kornfeld, and Brennan on behalf of the respondent Belair and Evans. I'd just like to begin by providing some factual and legal support for our primary argument, which is that Dr. Rizzo does not and cannot allege.
Counsel, I have some questions about procedure. It seems to me that Justice Nervo directed you in his March 29th order to address why the legal malpractice claim shouldn't be dismissed. And then he also dismissed 4 other counterclaims as well. Had you been put on, is there any way that you were put on notice that that he was going to consider addressing the other 4 counterclaims as well?
The sua sponte order was rather brief and mentioned the legal malpractice claim and the argument.
So was that a no, you were not given notice that the other 4 counterclaims were going to be considered?
Correct. So the argument that we made was saying that the other causes of action were duplicative of the legal malpractice cause of action because they're premised upon the same facts and they seek the same relief.
So if we found that they weren't duplicative, then you would agree that the doctor didn't get notice that the court was going to dismiss those claims?
Well, I think that the order speaks for itself.
I know, I'm asking you. You just said, no, the court didn't give anyone notice that it was going to look at the entire complaint. The notice was on the malpractice claim, you argued duplicative. If we find those other claims aren't duplicative, then you would agree that the doctor didn't get notice that those claims would be dismissed. We're subject to dismissal.
Well, when I put in my brief before the lower court, I argued that they were duplicative of the legal malpractice claim, and Dr. Rizzo's counsel responded to that and had an opportunity before the lower court to explain and cite to his pleadings why those causes of action weren't duplicative, and they didn't do so. They failed to do so because those causes of action are duplicative. They're premised upon the same factual allegation that my client provided negligent representation, that there was some type of conflict of interest because Attorney Belair represented hospitals in other cases, and he alleges the same damages, damage to his reputation, termination from his employer, increased malpractice premiums. So it's all basically the same. It's just a legal malpractice cause of action with some different verbiage.
And did you address that in your affirmation or a memo of law?
That was fully before the court in both the affirmation and the memo of law.
Thank you.
So speaking, if there are any other questions, I can pivot briefly to the but-for proximate causation argument, and I submit that that Dr. Rizzo has not and cannot allege that he would have prevailed at an OPMC disciplinary hearing or allege in a non-speculative way.
There is, just to be clear, there is no allegation that he would have prevailed in the complaint, is there? Is there any allegation that he would have prevailed?
Well, I think that's what he has to allege.
No, but does he allege it?
I don't see it in the complaint. So I think that the complaint fails on its face, but for Dr. Rizzo to have a meritorious cause of action for legal malpractice under but-for causation standards, the well-developed precedent in New York State, Dr. Rizzo has to show, but for my client's alleged negligence, that he would have prevailed at the OPMC disciplinary hearing, or somehow that a more favorable settlement could have been negotiated. And the evidentiary submissions in this case are really overwhelming. The OPMC collected certified patient records from Dr. Rizzo's office and from Lawrence Hospital on multiple occasions. They consulted with 2 independent orthopedic surgery experts who reviewed the certified patient charts and opined that Dr. Rizzo's medical treatment and record-taking in at least 15 patient cases did not meet the acceptable standards of medical care.
What do you do with the allegation that your client didn't get all the documents that your client was supposed to get, and so therefore couldn't properly argue the case?
Well, he did get the documents, and the question is whether...
Are you saying because he got the electronic documents but not the paper documents?
It's not a paper versus electronic thing. He did get the documents. He investigated it. He had the cases reviewed by an independent defense-friendly expert. And the strategic decision that was made was, let's not give the OPMC any more ammunition because they've already been investigating Dr. Rizzo for several years, and they have more than what they need to show professional misconduct as defined under the New York education law.
Thank you very much.
Thank you. Thank you very much.
Your Honor, I'll just briefly address the other point. I think paragraph 44 of the counterclaim also talks about the direct and proximate cause of plaintiff's negligence and malpractice caused the injury suffered to the counterclaim plaintiff.
No, that's damages. We're talking about but for. If the result would have been different, that's what you have to allege, right, in a legal malpractice case. Where's your client alleged that but for those alleged failures, he would have either prevailed at a hearing or taken a different settlement?
Well, Your Honor, I think throughout paragraph 42 where we outline all the different areas by failing to explain all the...
Paragraph 42 addresses negligence. Paragraph 44 addresses damages. But there's no paragraph that says, but for their negligence, these damages wouldn't have happened. Or at least I can't find anything that says that. Can you show me where it says that? It's not in 42 or 44.
Your Honor, I think the entire complaint says that. I mean, that's the whole basis for this allegation. I mean, and to the question earlier about the records, that's the basis of plaintiff's complaint. It's been throughout. That's the whole purpose of the discovery that we got into. They did not get the hospital records. Mr. Belair himself says it as referenced in our reply brief. Mr. Belair says, I did not send them anything. He did not get the hospital records.
Thank you very much.
Thank you, Your Honor.
Hillerman Holding versus VCW Associates.
Good afternoon, and may it please the court, Larry Robbins for Appellant Telemann. This appeal turns on the plain meaning of 3 lease provisions, each of which must be fully enforced by its plain language. There's a prevailing parties provision, which entitles them to their attorney's fees for having prevailed.
Counsel, let me ask you a question. There's some basic rules of contract construction, including that a more specific provision rules over a more general provision.
Correct.
Why shouldn't paragraph 19 of the lease control over paragraph 2 of the lease based on that canon of construction, that it is a more specific provision as to what should occur in this particular situation where there's a prevailing party?
Because that principle, the specific general principle, arises only when the provisions are actually in conflict, and they are not. Each provision can be fully enforced by its terms.
Well, you're saying that, but paragraph 19 says the prevailing party gets attorney's fees. If we enforce paragraph 2 in the way that you wish us to, wouldn't that be undercutting paragraph 19? Because if prevailing party would in effect not only not get their own attorney's fees of the full amount, but also be subsidizing the litigation against them. So on both sides of the equation, it would be undercutting the language of paragraph 19.
No, I respectfully disagree with that, Your Honor. They get their full attorney's fees. We write them a check for the full amount. They then, pursuant to their obligations under the rent provision and the plain language, which includes legal fees, in the rent provision and in the proprietary lease, have an obligation to pay 20% of the cash requirements, which include legal fees. What the court would be doing, were it to credit this argument of specific general, would be to imply an exception to legal fees and cash requirements, which is not there.
Is it an exception, or is it a more specific provision having to do with legal fees?
No, they are both as specific as can be with respect to very different issues. Neither one is more specific.
The cash requirements provision doesn't say the sum must include legal and accounting fees. It says it may include, among other things, legal and accounting fees.
Yes.
So we have to therefore interpret the may to make sense of the rest of the lease. And it seems to me that if we interpret that as you say, then the prevailing party will not receive its entire legal fees.
No, it just means that...
Excuse me, which seems to me to undercut, as Justice Kern said, the provision 19.
I respectfully do not think that's the case. They get their full legal fees, and we get...
And then you take it back.
No, they pay rent, which is their obligation. But imagine, for example, a slightly different hypothetical. Imagine the rent, instead, as the rent provision said, you must pay $100,000 a month. Suppose that were the case, rather than keying it to cash requirements. Could the tenant, the commercial tenant, come in and say, oh, I don't want to have to pay $100,000 because to do that, I'm going to have to give you back some of my attorney's fees. That, of course...
No, but let me ask you this other question. Here's another scenario that you're saying the tenant has to partially finance every one of the landlord's attempts to get out of this sweetheart deal. Every time you sue this tenant to get out of the sweetheart deal, no matter how meritorious or not meritorious, the claim is, you're saying that tenant's got to pay for part of your attempt to get out of that lease.
Well, no, I don't think that.
That's exactly what you're saying. Anytime I sue you, even if you win, even if it's the least meritorious claim ever, you still got to partially finance me.
Well,
Is
look,
that not correct?
I think it is, first of all, not correct. It's also not this.
Why is it not correct?
It's not correct because there are, in any lease, there are provisions that are beneficial to the tenant, and there are provisions that are beneficial to the landlord. It's a compromise like any other contract. They have benefited to a fairly well from this cash requirements.
Excellent. I agree with you. It's a
And
sweetheart
they have
lease,
made
right?
out-
Not disagreeing, but again, how is it not that every time you sue them to try and get out of the sweetheart lease that you are trying to get out of, that how is it that they're not going to have to, if we agree with you, partially fund your lawsuit?
Well, the answer may be that in the event you have a frivolous lawsuit, there are consequences, including the possibility that you will be disallowed from enforcing certain of your rights. Courts have that authority. But what courts do not have the authority to do, but which the Supreme Court respectfully did do in this case, is to carve out an exception that is not in the lease.
Thank you very much. You'll have time for rebuttal.
May it please the court. Deborah Koplovitz from Herrick Feinstein for the respondent, VCW, and it's one of its partners, Lars Cederholm. Your honors were exactly right on point. Teleman's latest request for a judicial rewrite of the prevailing party's lease violates our well-established principles of contractual construction and interpretation. Telemann is, as you just heard, asking for a back end of 20% out of the prevailing party award, which Justice Crane correctly said was an erosion of their rights under paragraph 19 of the lease. We have it's clear, as Justice Kern and Scarpula pointed out, that this lease is very clear. The specific prevailing parties provision of 19 is an override to the general provision of paragraph 2. We absolutely have a situation where there's prescriptive language, not mandatory, permissive language, not mandatory language, that it may include general legal and accounting fees in paragraph 2. Does not relate to litigation costs. The only litigation cost paragraph is paragraph 19. And as your honors heard from my learned colleague, what they are specifically asking to have here is two different paragraph 19s, one that applies to them and one that applies to the tenant. They want not only to have a back end and erosion of 20% out of VCW's rightful award to all of its reasonable attorney fees that were awarded, but they also want us to fund their litigation to the extent of 20% every time they come to court. And those issues just certainly cannot stand, and we cannot have a judicial rewrite of this lease, given the very specific and longstanding New York State provisions on contract construction and interpretation. I would like to indulge the court with a few more arguments that we've made. My learned colleague also improperly suggests that Justice Crane invalidated provisions of the lease under the guise of contractual interpretation. That's absolutely not the case. Every provision of this lease still stands. There's a clear indication in the record that Justice Crane was very concerned with this very unequal treatment and unfair application of paragraph 19 to both parties of this lease when she asked my learned colleague if the co-op would apply the same discount in the event that VCW were to lose in the future. And the answer was an unequivocal Absolutely not, on page 24 of the record. They want to have two different provisions, and that's not what this lease says. We heard it today again from Mr. Robbins that that there are provisions beneficial to the tenant and beneficial to the landlord. Paragraph 19 is one paragraph, and it applies equally to everyone. And their request for this unequal treatment to both parties of the lease is contrary to our law. If your honors will just indulge me with a conclusion, I think it flashed red. Yes?
No, it
No.
it hasn't flashed red.
Oh, great. Okay, thank you.
Still white.
The policy on strict construction of legal fee provisions in New York, the policy on reading a lease as being clear and not ambiguous, the policy on harmonizing provisions of a lease, the policy on specific provisions over general in our state, the policy that contracts cannot be read to create an absurd or unfair result, and the policy that a court cannot rewrite terms of a lease are all the policies that Justice Crane was correctly concerned with. She did not rely on any one of those policies to invalidate any provision of this lease, and we respectfully disagree with our learned colleague on their arguments in favor of their request for a reversal. Had Justice Crane permitted them to recover both back-end out 20% and also recover 20% of their own unknown amounts of litigation costs in this brief, it would have cut a huge hole into the clear provisions of paragraph 19, and Justice Crane was correctly concerned with not having that happen.
Thank you.
Thank you very much.
Very briefly, there's no need to recur to policy arguments in this case at all. It is governed by plain language.
I agree. So with that, let's just go back to, I believe it's, paragraph 2. When it's talking about the cash requirements, which includes, the accounting fees, legal fees as it relates to the ownership, maintenance and operation of the building. So certainly, you're always going to incur fees with those areas, right? But litigation is nowhere mentioned. It's mentioned in 19. So how is it that you are including litigation when it's silent in paragraph 2? But certainly, it is in paragraph 19.
Yes. Well, paragraph 19 is only about litigation, so it's scarcely surprising that it mentions litigation. Whereas when you want to capture a broader category, you use phrases like legal fees. Now, let me...
Right. And so when it's broad, you'll agree that it's always the specific that trumps the general.
Yes, if they were in conflict, but they are not. And let me just make one last point, because I know my time is up. The proposition...
Very quick last point, because your time is up.
Yes, I understand.
Okay.
You heard my opposing counsel mention one policy, which is correct, which is that fee-shifting provisions are narrowly construed in New York. That means that if you're putting your thumb on the scale anywhere, it is against, not in favor, but against the broad reading of paragraph 19. And to do what my opposing counsel suggests would require you to read into legal fees an exception that is not there.
Thank you very much, counsel. Thank you. The next case is Casella Construction versus 322 East 93rd Street.
May it please the Court, Brendan Fitzpatrick, counsel for the appellant Casella Construction. Your Honors, what we have here is a situation where Casella Construction performed emergency work on a building. It was not paid for that work. It asserted a lien.
Counsel, wasn't it paid for the work exactly what it bargained for? Didn't its contract say that it would accept as total payment for the work the insurance proceeds from the other contracting party, and it did in fact receive the full amount of those insurance proceeds from the other contracting party. So didn't it get paid exactly what it negotiated for in full?
No, Your Honor. I believe Mr. Casella explained that in a situation such as this, when there was not only damage to the 324 East, there was also damage to the adjoining buildings. And
Where
as the
does it say that in the contract? The contract, as Justice Kern said, is very clear. Where does it say that there's some add-on to that?
There's not an add-on, Your Honor, but when the DOB issued additional violations to each building.
Counsel, let's go to the actual language, because you're claiming that the work you did in the other building was an add-on. But when you go to look at the language of your contract with the original owner of the building you did the work with, it specifically defined the scope of work to include the installation of tiebacks and other required party wall support in adjacent structures and all additional work reasonably inferable from the foregoing scope to render a complete project. So didn't it in fact envision in the original contract that there would be work done in the adjoining building to complete the scope of the original contract?
I don't believe it envisioned the actual full scope of what was going to happen, and that's what Mr.
So
Casella...
what was done in the adjoining building that's not encompassed in the language that I just described to you?
I believe what Mr. Casella said and what Mr. Albanese, their public adjuster, agreed to was the stabilization, the waterproofing of the party walls, the sidewalk scaffolding that was put up. All that was specific for 322 LLC. Mr. Casella testified to this. This was what...
But we first always go to the language of the contract. It says other required party wall support in adjacent structures. Why wouldn't waterproofing be part of that other required party wall support in adjacent structures?
Your Honor, I believe this is what Mr. Casella said. This was the standard
I understand he said it, but the fact that he says that is not enough by itself if it's not supported by the language of the contract.
I understand, but when the DOB issues specific violations to 322 and 326, requiring additional work to be performed on those...
So did Mr. Casella ever go to 322 and 326 and say, I need to negotiate a contract with you because your work is not covered by my contract in 324?
No, but...
Okay, never went to the other two owners,
well,
right?
322 was issued a specific building violation where they were directed by the DOB to hire their own professional engineer, to hire their own contractor. They did not. They relied upon...
So again, did Mr. Casella go to them and say, hey, let's make a contract if you want me to do this work?
In hindsight, Your Honor, he did not go back.
And the contract that he did make is pretty broad about what he's going to do, right?
Your Honor, in his contacts with Mr. Albanese...
No, we have a contract. And
Your Honor,
the context is I signed a contract. And I'm bound by that contract unless either there's a modification, which you and I just agreed there's not, right?
I believe there is, Your Honor. With the DOB issuing a specific violation of 322,
is there a modification for 322 to have to make any payments?
No, there is a specific modification where DOB was required to have specific work done to hire their own contractor and own engineer, and they did not do
Again,
that.
so then the question I ask you is, was there a modification of the contract between 322 and your client?
Your Honor, I believe it was implicit. It was implicit with his contacts with Mr. Albanese, who was contractually authorized to settle this and negotiate this property damage claim.
Counsel, you seem to be saying that DOB's issuance of a violation modifies the contract. I'm having trouble understanding how that would work. If your client agreed to do more work, it doesn't change the payment provision in Article 4 of the contract sum.
I believe when he was negotiating this issue, when he was in constant contact with the representatives for the buildings as this additional work was being performed, because he could not know in the beginning how much the work was going to be. So when he was negotiating with these public...
So then why didn't the contract say that? Why did the contract say, no, I'm going to take whatever your insurance company paid? Why didn't the contract say, if that's what he thought was, I'm going to take that, and then at the end, we'll do a true-up? didn't say that at all, and many contracts do. So you're telling me that the parties meant something different than what they wrote.
Because, Your Honor, this isn't a typical contract. This isn't a typical situation where you have someone being able to estimate a job 4 or 5 months out. He was there the day after a 6-alarm fire, and he needed to do everything to stabilize those other 2 buildings and to demolish the 1 building.
Thank you very much.
Thank you, Your Honor.
Have time on rebuttal.
Good afternoon. May it please the court, Chris Georgioulis for the respondent. One of the things that counsel has conflated, not only here today, but in the documents, Your Honors are correct. The contract says you're going to get, and they agreed, whatever the insurance company determines. The fixed part of that isn't a dollar amount at the beginning, because he's right. Nobody knew what it was going to cost. But that's not how it was done. His client admitted he files a proof of loss. He takes his costs.
And did that proof of loss include the work to your building?
Of course. I'm listening to this, and it's crazy. This guy has done 100 jobs with Azes, Bruce Azes, who was the adjuster who brought him in. You think he's a fire restoration company. He does this all the time. So he knows that they're going to approve. He's going to get his cost, profit, and overhead on top. But here, what happened here, he saw an opportunity to grab additional money, and that's exactly what happened. There was nothing else.
So how do you explain Mr. Albanese?
Mr. Albanese, if you look at it, the affidavit of Greg Casella, Mr. Albanese first appears in this action in opposition to the summary judgment motion. In the complaint, nothing about Albanese. In the deposition of my client, no questions about Albanese. In the deposition of Casella, nothing mentioned about Albanese. In a letter from the attorneys to my client for the first time in February, I think that's R452, but I'm not sure, where they're saying, we're making a claim a month after the work is done. And he says, and I'm going to copy your representative. Who's the representative? AIG, who's my client's insurer. Nothing about Albanese. And, by the way, in the paragraph, in the affidavit, it's an admissible hearsay, at least 2 levels. Because Casella says, I spoke to this guy, Winthrop Green, who told me, let me speak to Albanese. Well, what is that? How is that admissible?
And counsel, since we're on, Casella, now, Casella also admitted, right, that he never even discussed the price with 324, either before or during, and actually said that he only expected payment from 322 as per the contract.
The very short excerpt I put in the brief around page 6 or 7, where I ask him, well, he says, yeah, he got paid as he expected. And that's the reason he never had a conversation with my client, because he was expecting the money from the proceeds and nothing to do with my client. By the way, there were 11 emails exchanged between my client and Casella, not one mention of Albanese. In fact, my client said, I'm not signing anything that puts cost responsibility on me. And the trial court made a note of that in its decision, and also said AIG rejected the claim. So who's going to pay for this claim? My client had no responsibility. The administrator...
Wait, you put in that claim to your insurance company and they rejected it?
Absolutely, it's in the record. And I mentioned it. I don't remember the page right now, but it's in the record, and it was rejected. And the court, in its decision, said straight out. I mean, this is a clear-cut case of what lien law 39 and 39 was intended to prevent. Liens filed, because when you file a lien, you put a lot of pressure on the property and on the property owner and on banks, and it causes a lot of leverage adverse to the property owner. Yeah, and this is, they try to force settlement. My client wouldn't settle. Didn't have a bank to deal with. There was no mortgage on the property, so she didn't have to deal with that. But meanwhile, all it was a money grab, plain and simple. If there's any other questions, otherwise, I'd ask the court to affirm.
Thank you very much.
Your Honor, before I leave today, I would like to address the issue of willful exaggeration. Your Honors, regardless of whether this court finds that the mechanics lien was void or it should have been voided, the fact of the matter is there is documentary and expert evidence to show that there was no willful exaggeration here.
Counsel, couldn't you have brought this claim as unjust enrichment or quantum merit or breach of contract? It was your client's choice to bring this in the form of a mechanics lien, which does have a lot of implications that go with it, including the right to extra damages of the opposing side if willful exaggeration is found. But that was ultimately your client's choice to go forward using that vehicle.
Yes, Your Honor. But when confronted with that, and with allegations of willful exaggeration, at the very least, when the evidence has to be viewed in the light most favorable to my client, he submitted documentary evidence that's without dispute, that it was $1.5 million to complete all the work, that the public adjuster, who was contractually and legally authorized to negotiate and settle and adjust this property damage claim as a result of the fire loss, he agreed to the split. Whether Mr. Casella was wrong to rely on that, that's one thing. But to say that he willfully exaggerated anything—
You understand, counsel, you're saying it's not willful
It's not willful exaggeration.
Thank you very much.
There's undisputed expert evidence
Thank
to
you.
support this,
Thank
Your
you.
Honor. Thank you.
The next case is People versus Alvarez.
Good afternoon, Your Honors. Robin Richardson with the Legal Aid Society on behalf of Mr. Alvarez. The fee waiver law was passed for people exactly like Mr. Alvarez, who was 20 years old at the time of his conviction, or at the time of the offense. He was a brand new father, and he was living at home with his single mother and little sister. There is no question that the imposition of fees and surcharges in this case would cause an unreasonable hardship not only to Mr. Alvarez, but to his single mother, to his girlfriend, and to his newborn child. Additionally, fees would adversely impact his reintegration to society. Now, relief in this case can be granted retroactively. This is an ameliorative statute. Ameliorative statutes are applied retroactively unless the legislature intends them not to. Here, there's no indication that the legislature did not intend to apply this case or these laws retroactively. And it's very clearly an ameliorative statute. The legislature stated, as they were passing the law, that this was being passed in order to help not only indigent defendants, but also their families and their communities, especially in reducing their financial distress that the fees would impose on their families, and to promote their integration into society. So if there are no further questions.
So the record doesn't contain any information about his present sources of income or the impact of payment on his family specifically, does it?
Your Honor, the pre-sentence report indicates that he did have prior employment in fast food and then with a party planning organization, but there's no information about his current income. But he was obviously indigent as he qualified for legal aid services. Thank you.
Good afternoon, Your Honors. If it please the court, Kay Trifon for the people. First and foremost, Your Honors, there was a valid waiver of appeal here.
Counsel, I wanted to ask you about that. Was the waiver here valid? Did it sufficiently advise the defendant what he was giving up?
Yes, Your Honor. Not only did the court, there was a brief colloquy, but most important about the colloquy was that the court separated out the appellate rights that he was waiving from his trial rights. And the court, in fact, said, we're now going to talk about your appellate rights. The court then reviewed the written waiver, which was very thorough, which is available in the record to review, and asked the defendant, I believe at least twice, have you gone over this with your attorney? The defendant replied yes, and the defendant then signed it in open court.
Did the court advise the defendant of what rights survive the waiver of right to appeal?
The court did say that the defendant would be appointed an attorney for the appeal, that the attorney could then review the defendant's entire case, not just what they were talking about at the time. And then, as I said, he parsed the trial court did parse that out and then turned to the written waiver.
That doesn't answer my question as to whether the trial court advised the defendant of what rights would survive the waiver.
The rights were contained in the written waiver, and the trial court did ascertain that the defendant understood and signed the waiver.
So you're saying the trial court did not specifically advise him orally?
There was not an extensive colloquy, Your Honor. However, the courts have upheld that where the written waiver is thorough and valid, that will suffice for a valid waiver of appeal. As to my opponent's brief point, if there are no further questions about the waiver, I would just like to say that the statute here is not retroactive. That being said, however, even if the court is inclined to review this in an interest of justice, this is not the case. This is not the case to apply an interest of justice approach. As I believe the panel somewhat indicated, all that we have here is that the defendant was 20 and that he's indigent.
Well, don't we have a little bit more? We have that he was 20, he was indigent, he was soon to become a father, and I think I read somewhere in there that it said that it was his mother that was likely to bear these costs, right? In light of that, and in light of the fact that at these criminal trials, at sentencing, or in any step of these criminal trials, very rarely do you get into the facts that you need, the specific facts that you need to apply this statute, right? And the purpose of the statute is to make sure the defendant could reintegrate into society. It's not intended to be a further punishment. So why shouldn't we apply it here?
Okay, sure. Maybe not at trial, but the PSR does do a thorough investigation of the defendant, an interview of the defendant. There was no further information in the PSR. And moreover, Your Honor, this was a gift of a plea that he took for...
That's irrelevant.
Counsel, wasn't the defendant rearrested for another gun trial?
Thank you, Judge. Yes, he was rearrested for possession of a gun and possession of marijuana, which presumably he purchased. So the...
Counsel, but again, the purpose of the fee-waiving statute is not to punish, right? It's to make sure that the defendant could reintegrate back into society. So this is not going to apply unless there's a conviction. So why are we talking about the convictions when we're talking about whether we should waive the fees?
Because in looking at it as a whole, Your Honor, this is not the defendant to apply an interest of justice approach here. Like I said, he had 5 open cases when he pled to this. The fees in total were $375. While he was out on sentencing for that, he was rearrested for possession of a gun and drugs, which presumably he had money to go buy. If there are no further questions, we ask that the court affirm.
Thank you very much.
Thank you.
I'd really quickly like to address the waiver issue. The court actually did not do a very good job of explaining the rights that survive a valid appeal waiver. And with respect to my opponent here, the court actually said that the right to appeal included the right to have an attorney on appeal, and then said, when you waive your rights, you waive all of your appellate rights that are possible under the law. So it was really a suggestion that he was actually waiving his right to an attorney on appeal and not advising him of his right to have an attorney on appeal in spite of a valid waiver. Thank you very much.
The next case is Phone Administrative Services versus Verizon, and I am recused on this matter.
You may proceed.
May it please the court. Greg Skidmore on behalf of the joint defendants appellants. The False Claims Act imposes certain threshold requirements that are not present in other cases, and the complaint here does not satisfy them. First, PAS's claims are barred under the public disclosure bar of the False Claims Act. As this court held just last year in the Solomon versus Siemens Electric case, a court must dismiss a False Claims Act case when the allegations are substantially the same
as information that has been publicly disclosed. PAS does not address Solomon in its brief, and it has no good answer to it. This case presents an even stronger argument for dismissal under the public disclosure bar. The allegations in PAS's complaint have been disclosed going back over a decade, including in a front-page story in the Wall Street Journal and in multiple government public audit reports.
But isn't this different from that because the articles in the record indicate that the state investigations and suits were largely prompted by the efforts and investigations by plaintiff and its affiliates?
Well, Your Honor, some of the articles do mention the plaintiff and their affiliate, Roger Schneider, but many do not. And importantly, there's no exception under the public disclosure bar for some of the disclosures mentioning the relator here. And importantly, a number of the disclosures, including the government audit reports and the lawsuit that was brought by 6 New York counties, say nothing about PAS or any of its affiliates. And that's the important part. The public disclosure bar asks whether there are disclosures in the public that are sufficient to put the government on the trail of the alleged fraud. Here, we know that for a fact because we have at least 3 government entities in New York that performed audits about 911 taxes, and we have 6 New York counties.
So then, counsel, how do you distinguish phone recovery services versus Verizon Washington, 191 83rd 309, phone recovery services versus Ameritech in the Illinois Court of Appeals? How do you, I mean, this is not the first time this issue's come up. And those other courts have found that the public disclosure was not sufficient in those cases, and it's the same public disclosure here to warrant dismissal of the complaint.
But it's not the same public disclosure here, Your Honor, and that's the key point.
What is different?
What is different here is we have 3 New York government audit reports, which were not, could not be applied in DC or Illinois. We also have a lawsuit brought by 6 New York counties that again could not be considered.
Wait a second, were those brought after, were those audits done before or after this complaint was filed?
They were done before the operative complaint.
And they were published before the operative complaint?
Yes, Your Honor.
And I mean, but the fact that individual counties or bring their own lawsuit doesn't affect whether or not there's the public disclosure sufficient to vitiate a QI-TAM action. So I'm not sure that that has anything to do with it. But why is it that those investigations, are you saying, make this different?
So the investigations and the lawsuit show that there were enough disclosures out in the public to put the government on notice. The False Claims Act is a narrow exception to the general rule that a party has to have their own injury to bring a claim. And a relator under the False Claims Act gets up to 1/3 of the government's recovery. And so the False Claims Act only allows the relator to proceed if the government needed the relator to bring to light the allegations. The government did not need the relator here. The government had enough information to do its own audits. 6 counties had enough information to bring their own lawsuit. They did not need the relator to bring this to light. And that brings me to my second point, which is
so let me ask you this. The public disclosures, did they disclose the undercounting of the VoIP lines?
They did, Your Honor.
Did they disclose multiple locations as a single location? This is some of the stuff that's pled in this complaint for fraud, right? Was that, you're saying that the public disclosures disclosed the using resellers to conceal the non-collection of surcharges?
Your Honor, the public disclosures disclosed the issue about the PRI line.
See, how the whole idea about public disclosure, right, is that you don't want some person who really has no interest in this and hasn't done any work in it reading a few articles in the paper and filing a lawsuit. So that you can't just say generally there was some fraud in the air. You have to show specifically that the fraud that's alleged in this claim, which the plaintiffs allege that they rooted out, and certainly other courts have found that, was known by everyone. And so I'm asking you specifically about these parts of the fraud, because generally, sure, was there knowledge of the fraud? Okay, I'll accept that, but that's not what the test is.
Undercounting access lines for business services was disclosed in the Wall Street Journal, Fortune magazine, the Philadelphia Inquirer, and the Boston Globe.
Before this?
Before the operative complaint was
Before
filed.
the original complaint was filed?
No, Your Honor, before the operative complaint was filed in
No, I'm
2021.
talking about the original complaint.
So, Your Honor, under State versus Wisconsin in this court, it is the complaint that adds these allegations you're pointing to, Your Honor, those weren't raised until the complaint in 2021. So that is the complaint we look at to see what public disclosures came before that.
And you're saying the treating of multiple locations as a single location was revealed in public filings before?
It was, Your Honor, in the Knoxville News Sentinel back in 2011. And the failing to
using the
collect 911
retailers-
surcharges.
I'm going to just go through some of these. Using resellers to conceal non-collection?
The failing to collect, which is the reseller allegation, was disclosed in a number of articles, including the Pittsburgh Tribune Review, the Erie Times News, and the Chattanooga Times Free Press. All of these are in the record, Your Honor. And importantly, the PRS also does not have standing to bring this claim because they brought it on behalf of the wrong government entity.
Well, how come the state of New York thinks they have standing, correct?
No, the state of New York said two things, Your Honor. The first thing it said is that they complied with the procedural requirements of the False Claims Act. That is different than saying they have standing. And the second thing the state of New York said was that it would, if you adopt our position, that it would impact their ability to enforce the False Claims Act. And that is also not correct. This case has nothing to do with the state of New York and its ability to enforce the False Claims Act. And this ruling for us would have no impact at all on the state's ability to enforce the False Claims Act under either 190 Section 1 or 190 Section 2. This case is about whether a relator can bring a claim under the False Claims Act. And ruling for us also will have no impact on the ability of relators to bring it, because all that happened here is that the relator brought it on behalf of the wrong government entity. They could have easily brought it on behalf of the counties, which are the proper government.
But doesn't the statute say that you can bring it on behalf of the state?
The statute says you may bring it on behalf of the state or local government as applicable for a civil penalty plus damages which the state or local government sustains.
Counsel,
Here,
you have time on rebuttal. Thank you.
thank you, Your Honor.
You may proceed.
May it please the Court, Bethan Jones speaking for the AT&T and CenturyLink defendants. We agree with Mr. Skidmore that all defendants should be dismissed, but CenturyLink and AT&T are uniquely deserving of dismissal, and that's why they filed separate appeals to highlight two issues unique to them. First, PAS has no New York telephone bills or any other New York information about these defendants.
But isn't the allegation that the billing practices are national, so it doesn't really matter whether there's a New York bill or not?
Your Honor, the allegations that these companies engage in nationwide practices is itself an allegation based on information and belief, and that's most clear in paragraph 102 of the complaint and 112 of the complaint. Now, the basis for that belief that PIS identifies is a handful of out-of-state phone bills. PS's theory is that those phone bills support an inference that these companies underbill 911 charges, irrespective of the local law at issue, and even when the local law requires them to bill more. And that's why they support an inference that these companies underbill in New York. But that even when the law requires peace is a key component of the allegation, because otherwise you're just speculating that these companies are not complying with New York 911 laws, even if they may vary from the 911 laws in the other states for which PAS has bills. But no court or regulator has ever validated that belief. There's no basis for it. So all you're left with are the legal allegations that PAS makes, which this court need not accept as true.
And won't that be resolved by this litigation if it continues?
Excuse me, Your Honor?
You said it hasn't been resolved yet. Why wouldn't it be resolved by this litigation, and why wouldn't this be the right place to do that?
Well, PAS has to have a particularized allegation of underbilling to plead, a viable New York's False Claims Act claim, Your Honor.
Thank you, counsel.
Thank you.
Thank you. I'm Tejinder Singh for the respondent, Phone Administrative Services. I'd like to start just with the standing argument because it's a quick one to deal with.
I would like you to deal with the public disclosure one.
Sure.
I'm-
I was
the
planning to spend
standing
most
one
of my
is-
time there
and
because
the
Mr.
statute says what it says, right?
Sure.
So let's talk about that.
Yeah, absolutely. So the statute says that the public disclosure bar applies if substantially the same allegations or transactions have been disclosed in an enumerated public source. Mr. Skidmore couches the standard as whether there's something out there that could put you on the trail of fraud. That's not what the statute says.
No, when I asked him about specific fraudulent practices, he said that they were disclosed prior to the operative complaint. So I'm going to ask you the same thing. What about undercounting VoIP lines?
So not in New York is the important, so just to be, I want to be very clear about when we say substantially the same allegations and transactions weren't disclosed. You know, it is true that there are some articles, mostly reporting on lawsuits that my clients have filed that say in Tennessee, in South Carolina, phone carriers have been accused of underpaying, right? But there's nothing saying that the 5 specific kinds of fraud that we talk about occurring in New York were happening in New York. And I want to talk specifically about the sources Mr. Skidmore pointed you to so that you can understand this better. So you asked, what distinguishes this case from the DC case and the Illinois case, also cases involving my client's affiliates, where the public disclosure bar was found not to apply? Mr. Skidmore gave you 2 things. He said there are some county audit reports, and he said there's a lawsuit by 6 counties, right? Those are actually addressed very specifically in our briefs. The county reports are addressed on pages 59 to 60 of our brief, and so I'll just tell you what they said. You know, these 3 county audit reports, Suffolk County, Nassau County, and the state comptroller say, according to the defendant's description, they discuss potential issues with phone companies' billing, collection, and remittance of 911 charges, but the county audits were limited to Verizon and to only 2 counties. They don't discuss the other schemes alleged in the complaint or any of the other defendants. All they say is that Verizon took excessive administrative fees because when phone companies collect the 911 surcharges, they're allowed to keep a little bit to compensate them for the trouble. That has nothing to do with any of the 5 fraudulent schemes. Mr. Skidmore talks about the lawsuit by the other counties. You can read the complaint in that lawsuit and see if it bears any resemblance to the 97 paragraphs of detailed allegations we provide about our different fraudulent schemes. It most assuredly does not. And so unless you're going to adopt a very, very high standard of generality where any disclosure of fraud, however vaguely similar, is enough, you can't rule for them on the basis of these sources. Now, he's sort of spit out a bunch of other sources. I would say most of those, by the way, were not discussed at all in the lower courts. They're wheeling them out for the first time on appeal. And rather than go through them one by one, I think you would be on very solid ground saying you had your chance on these and didn't make anything of them. But in any event, they suffer from the same problems. And we've gone through these in some detail in our brief. They're talking about different jurisdictions or only a subset of the defendants, or they're saying that there's a general problem with 911 surcharges, but they're not saying these specific schemes, especially none of them talk about aggregating the locations because that's a New York specific problem. It only exists.
So then how do you deal with AT&T's argument that you don't have any New York specific allegations?
Yeah, fair enough. So I want to be clear what the information and belief is. It's true. Our factual allegation, which must be taken as true for present purposes, is they have a nationwide billing system, and it works the same way everywhere. For example, with respect to PRI, they take 23 lines, access lines, they bill them as 5, and that's our allegation against AT&T entities nationwide. The basis for that is that we have examined AT&T's practices more or less nationwide in many, many, many jurisdictions. And regardless of what the law says, this is what they're doing in all those jurisdictions. So that's a well-pleaded factual allegation that they also do that in New York. If we're wrong, they will win at summary judgment. We will lose if we're wrong about that fact, right? If they're complying with New York law, they have nothing to worry about. But we have a well-pleaded allegation, which is all we need at this point, because the particularity standard, and this is also important to emphasize, State Finance Law Section 192 expressly modifies the usual particularity standard that applies to fraud claims, and we've quoted this extensively in our brief, but it says all we need to do at this stage of the litigation is provide facts that, if proven true, show that it's reasonably likely that one or more violations of the statute are likely to have occurred. I mean, that's not a high bar. It's effectively notice pleading in the context of this statute. And so the standard is quite relaxed, and we have easily met it. If you look at our allegations, you know, the phone bills, the explanation for how we got them, and the investigations we've been doing provide more than enough for you to credit those factual allegations at this stage. And once you credit them, it is reasonably likely that at least one violation occurred, which is exactly what Justice Crane properly found. I'll also note, this litigation has since then been humming along. It's well through discovery now, getting closer and closer to summary judgment. If they are right that they didn't do anything in New York, they will win. But as of now, without talking about stuff that's outside the record, I'm not that worried. And so at the moment, I don't think there's any basis why you would go back and reverse the judgment on the pleadings and throw this case out altogether.
Thank you.
Your Honors, the standard on public disclosure is not whether they're identical. It's whether they are substantially the same to what has been publicly disclosed. And you look at all the disclosures in their totality to see if the allegations have been disclosed. And all of these reports, all of these newspaper articles, all of these audit reports, they're all in the record below. They were all in the record below for the trial court. And they all show that the allegations in this complaint are substantially the same as what was already publicly disclosed. On particularity, Mr. Singh says, basically, you know, we're close enough. But on public disclosure, it's got to be identical for us to get dismissed. Well, that's precisely backwards. The public disclosure standard is substantially the same. The allegations here are publicly disclosed, and PAS is not an original source, which is the only exception to the public disclosure bar, because nothing that they brought to the table was either independent or material. So, Your Honors, this is a case about the application of 911 tax laws. It's normally handled through a government audit, and PAS is trying to put a square peg in a round hole, and in doing so, they have violated these threshold legal requirements. We don't need to wait for discovery. These are threshold legal requirements that PAS was required to meet when it pleaded its complaint. It did not meet these threshold legal requirements, and the time to dismiss the case is now, like so many other courts faced with these exact same allegations have done, dismissing the case on the pleadings, on motions to dismiss, prior to discovery. The court has no further questions.
Thank you, counsel.
Thank you.
Last person had time. Okay. The next case is Rosenblum versus Trinity Hudson.
Good afternoon, Your Honors. Calvin Kamian, appearing on behalf of the appellant Kenneth Rosenblum. As the court is aware, this is an appeal from a motion granting summary judgment in favor of the defendants. It is settled law that if there's any doubt whatsoever regarding whether there are factual issues, or even if there's an issue that's arguable, then a motion for summary judgment should be denied. Consistent with that principle is the principle that the evidence should be reviewed by the court in the light most favorable to the opposing party to the motion. Furthermore, when there's disputes regarding experts, it's also...
Let's talk about your expert's affidavit, because the court doesn't have to blindly accept an expert's affidavit if it does not have a scientific basis for its conclusion. So where is the scientific basis for your client's expert's conclusions based in scientific methodology?
Scientific methodology, for one thing, just so it's clear, Mr. Cohn is a structural expert.
No, I understand that, but basically all he says is the same thing the complaint says. Defendant's pumping zone of influence extends under the entire foundation footprint of 25 Thompson. But that's not enough to just conclusory state that. You have to give your scientific basis for why it is doing that, how it is doing, how it's causing that. That's what I want you to articulate, how it's saying that.
That was, in other words, the probes, when Mr. Cohn was retained in late 2013, and he did 4 visits to the site. They conducted probes in the basement, besides various apartments. And when they conducted the probe in the basement, what they discovered that the earth from below the basement had actually been removed. So it was no longer there. And furthermore—
So what is his scientific basis to explain how anything that occurred next door caused this condition below the plaintiff's building? What is the scientific basis to explain how this occurred, other than saying it happened?
The scientific basement or conclusion was then it was determined in speaking to the various superintendents that they had seen water and sand pumped out from next door at 25 Thompson. And so you had a situation, it was a combination of a number of factors. You had the earth was gone from underneath the basement, the earth was gone from the sidewalk in front of it, and you had water and sand that was being pumped out as testified by
Where's the scientific explanation that shows that whatever, and there's a dispute about the water pumping, but whatever water pumping there was next door caused the damage to plaintiff's building?
Yes, because it led to the earth being removed. You had a situation where it was 12 foot deeper, the defendant's building as compared to the
This is what you say in your complaint. I understand that, but
the complaint—
the expert has to say more than that.
Your Honor, the complaint is based upon what the expert determined. The complaint wasn't taken out of thin air. It was a combination of a number of factors which led Mr. Cohen to conclude that the basis for the damages was exactly what was occurring here. The earth was being removed, and then furthermore, when they did the inspection of the defendant's building, there was literally dirt in the various pumping devices, and which was also covered in their reports. So the scientific basis was you had the zone of influence, you had the earth being removed, and it led to a situation where there was structural damage. And then you compare that to the building that's directly south, which is an identical building. They were both constructed at the same time, and none of these issues existed. And Mr. Cohen, who's a structural engineer, resulted in the conclusion that there was an impact in terms of what occurred by the defendants. And this is combined—
Wait, he based his conclusions on the pumping out of water from Sandy and Irene, correct?
In part, yes.
Right, well, the other part was I think the lower court said was beyond the statute of limitations, right?
Well, no,
and you didn't argue on appeal anything about the earlier.
No, on the statute of limitations, in fact, I have the decision here. What the judge said was, however, the court finds that plaintiff's claims of negligence, nuisance, and trespass with respect to defendants' use of the same pumps and other drainage operations assert continuing wrongs, and it specifically rejected the defendant's motion.
Right. So okay. Let me just ask you, your expert said that it was based in large part on the pumping out in Sandy and Irene, right?
For sure, yes.
And your client said, actually, that they didn't even know whether there was any pumping out during
No, that was incorrect. That was taking a certain portion from the client.
I read it, and he said, and your client said there was very little sand, very little silt. I don't even know if it happened during Irene and Sandy, That's what your client said.
No,
So
but-
if your expert, well, let's assume that I thought that that's what your client said.
Okay, but the client's
If
not the
that's
only
true-
witness.
Right, but if that's true, and your expert relied on Sandy and Irene, and your expert obviously wasn't there, the only person who was there was your client, and if your expert relies on something that your client
Your Honor,
testifies, let me just finish this, thinks is wrong, then doesn't that leave your expert's report suspect?
no, because the client is an owner of various buildings. He's not there all the time. The people that were there all the time on behalf of the client were the two superintendents, which were there at various times. And it was both testified under oath and both stated under oath that there were multiple times that they saw the water and sand being pumped out by hose.
Okay.
Thank you. Do you have any more questions? Thank you very much.
Thank you, Your Honor.
Good afternoon. May it please the court, William Gaggus, Vigorito Barker, Patterson, Nichols, and Porter on behalf of the respondents. The court hit it right on the head. There is no science to the plaintiff's theory, which they had at least 6 years and 30,000 pages of documents to formulate this quote-unquote zone of influence theory. It's not supported by any facts and evidence. Mr. Cohen is a structural engineer. He's not a mechanical engineer who can explain how it is a sump pump functions, which Mr. Dudley Smith, a mechanical engineer on behalf of the respondents, opined in detail. This is a simple half horsepower sump pump which you could have in your own basement. The quote-unquote zone of influence, I don't even mean to lend any credence to that theory because it's not scientific. Our experts refuted that. Its zone of influence, it's its own pit where the water comes up from the ground or comes in from a flood. And in fact, the pump doesn't even eradicate all of that water. Simply, it rises to a level where a float switch gets high enough that turns the motor on to bring the water level back down to an acceptable level.
How do you deal with the council's argument that the other building, which doesn't apparently have a sump pump, isn't affected by the sump pump pumping, has no defects to it?
Sure. Well, it's simply a statement on paper. There's no evidence to support that. There's a claim that this is, quote, the same age and vintage of their building, but they don't have any evidence as to when that 23 Thompson was constructed, that their expert ever did any kind of inspection, or lo and behold, what the building owner of that property did for preventative maintenance. What we do know is Mr. Rosenblum admits he's been aware of this exact same damage to his property since the 80s, 90s, perhaps even back to 50 years ago when he purchased the property in 1973, but he's entirely unfamiliar with the term preventative maintenance. His tenants are like flies. He doesn't need to listen to their complaints about the conditions of his building. He'll swat them away and replace them with others. So it's not a comparator to this property. They don't have any evidence to support that anything can be gleaned from the condition of that property versus this one. And then, lo and behold, there was no claim below. There's no claim here that the respondents didn't meet their prima facie case. We submitted significant and substantial evidence, including 3 expert affidavits, which utterly refute any scientific or factual basis to the claims alleged in this case. And the plaintiffs did nothing to refute it. And in fact, Mr. Cohen can't even state within a reasonable degree of engineering certainty that this zone of influence theory is valid. He states that it's quote unquote very likely that 25 Thompson was damaged due to Trinity sump pumps, which would have the potential to create continued movement at 25 Thompson. That's not a valid expert opinion. It doesn't rise to the level to refute a summary judgment motion. And again, the superstorm, there's really no debate that anything that happened during Hurricane Irene is barred by the statute of limitations. It was August 2011. This complaint is more than 3 years later in September 2014. And in terms of Superstorm Sandy, no one can refute that the electricity was turned off to the building for both of those storm events. The sump pumps were not operational. The water was not even fully pumped out of the entirety of
Trinity's basement, an inch or two of water was left. There were no pumps into the sump pits, which, again, is a 1 to 2 foot pit where this simplistic machine sits and just brings the water back down so that the building can be maintained in an effective manner. And if there were any credence to the zone of influence theory, Mr. Rosenblum admitted at times he employed a 1 to 2 horsepower sump pump at his own property, which his superintendents also confirmed. So if, in fact, these voids in the soil could be caused from a sump pump, well, how is it possible that the 2 to 4 times more powerful sump pump that he uses at his own property wouldn't cause those voids? Again, all of these theories, these quote-unquote facts in the records, were fully disputed and eliminated by our experts, including, as my adversary touched upon, the fact that when Mr. Cohen went to the property, there was dirt in the sump pit. Our experts tell you, the geotechnical expert Ted von Rosenfing, mechanical expert Dudley Smith, that's not an uncommon occurrence. It's a pit in the ground. There's some dirt in there. It doesn't mean that it's dirt, fine soil particulates from underneath the plaintiff's building, let alone does their expert say that. And the same thing as the court already articulated as to Mr. Rosenblum. He admits perhaps he observed sand coming out of, in water coming out of the Trinity building. He doesn't say that he...
Thank you.
Thank you, Your Honors.
Your Honor, just so it's clear from before, there were 3 witnesses. Mr. Castro and Mr. Borg were both superintendents, and they both testified that they saw extensively water and sand coming out. There was also Mr. Donamora, who was a...
So what evidence, you talked about the other building, what evidence did your expert look at with respect to that other building? Did they do any investigation as to what the other building was doing for preventative maintenance? Did they find out whether or not the other building had a sump pump? Did they know when that building, is there any evidence in the record when that building was?
They just did an examination from the building from the outside and its background. And
did they know when the building was built?
Yeah, oh yeah, the building, they were both built in 1905.
And did they do anything to find out what they had done in that building for structural repairs or anything like that? Look at any, so it's hard to say that that other building, there was a comparison unless they actually did a comparison.
They, as I say, from the exterior, they did a complete comparison. The other thing is...
Thank you very much,
Thank you, Your Honor.
Donlin versus NIO.
Good afternoon, Your Honors. Michael Capisi from Robbins Geller on behalf of the plaintiff appellants. Your Honors, we believe that the issue on this appeal is very straightforward. In resolving the motion to dismiss, the trial court improperly resolved factual questions and failed to give plaintiffs' allegations their most favorable intendment.
Counsel, what facts were specifically pled showing that there were problems or design challenges with the ESA at the time of the September 2018 IPO? Not before, not after, but at the time that the IPO took place.
Well, Your Honor, I think the facts here need to be taken holistically and together with one another. The fact of the manufacturing facility where the ES8 was being manufactured, the problems were observed there. The meetings with...
Sorry, when did those meetings take place?
The meetings that were involved, that had the involvement of NEO's directors and senior management, we allege took place in 2017 and the first half of 2018.
Okay, so what allegation is there in the complaint, taking all the allegations in the complaint is true, that these problems mentioned in the meeting still existed at the time of the IPO?
Yes, Your Honor. So there, we have, the allegation there is the CEO's admission. The CEO admits after the IPO that there were existing operational problems as of the IPO and before the IPO.
What did he exactly admit? You say that, but what exactly were his admissions that you're relying on?
Your Honor, I believe we recited in the briefing. I mean, I can read them from the record to you if you would like. But in some substance, he admits that there were challenges and that they needed to.
What does that mean, there were challenges?
Well, I think it means what it plainly states. And the problem here is that the trial court is saying that we have to that there's some gap or there's some disconnect. We allege the existence of the problems. The defendants have cited no case. The trial court cites no case showing that we would have to prove that somehow things changed in the 3 months between the end of those meetings in June of 2018 and the IPO, the fact that the CEO is admitting that those problems were ongoing, and the fact that they're being observed daily where the car is being manufactured. What that is essentially asking for is more particularity. And we're here on a 3013 motion. We're not here on 3016.
You don't need particularity, we know that. But let's say, assuming that you've stated these allegations of design problems, how do they rise, since you're being very vague what these design problems are, how do they rise to the level of materiality?
Well, I don't think we're being vague with them. We detail, we detail what they are. One of them being the fact that the batteries were leaking and having charging problems. What happened subsequently after the IPO is that the battery started catching on fire. And
that was significantly after that was not at the time of the IPO. That was after, and wasn't that something that was fully disclosed in the risks, that this was something that could happen?
No, Your Honor. It was something that was in existence as of the IPO. The company understood as of the IPO that this problem was occurring. That it manifested after the fact. See, if you follow the Panther Partners decision, the Panther Partners decision that the trial court relies on is essentially saying, if all we had was the battery fires and we didn't have the earlier allegations, then I would agree with you. Panther Partners is right. But if you look at the second Panther Partners decision, and in that, and what the plaintiff subsequently alleges, and my firm was counsel in that case, I know the case very well, the plaintiff subsequently alleges the prior IPO existence of problems. And what the court then says is, no, there's no mechanical increase. The plaintiff doesn't have to go and show how much of a defect rate there was or what the rate of deviation is or any sort of additional detail. Under the notice pleading standard, that's more than sufficient. And I think that's it here. If you look at Panther Partners 2, the second Panther Partners decision, and you see what the trial court did in relying on the first Panther Partners decision, the court recites our allegations that we just discussed and doesn't give them credit. We're entitled to the most favorable intendment. And the most favorable intendment is that those problems were existing as of the IPO. And when you have the battery fires after the fact, they went and they recalled every ES8 that was manufactured from April to October of 2018. That means the cars coming off the production line September 6, 2018, when the IPO became effective, had the problems. And they knew it because they were meeting about them, it was being observed in the manufacturing facility, and the CEO alludes to them.
Also, didn't the prospectus specifically say that the lithium batteries, which had been observed to catch fire, vent smoke, and flame?
Yes, it did, Your Honor. And if you actually read the entirety of that risk disclosure, what it really says, and I'll direct the court to record 173, the defendants in their brief, there's an ellipsis. They cut out the important part. The important part says, we have designed the battery packs to passively contain any single cell's release of energy without spreading to neighboring cells. So what the registration statement, Your Honor, is actually saying is that we have specially designed this premium electronic vehicle, the battery of which is the absolute most important and key critical and material component of that vehicle. We designed it not to catch fire.
Thank you very much.
Well, wait, let me just ask this one question. Do you think they didn't design it to catch, you think they designed it in a way that they wanted it to catch fire? Isn't that?
Your Honor, I don't know what they thought.
They said, we've had problems with these. We've designed it in a way that we think is going to fix that.
Yeah, and they knew that wasn't accurate based on our allegations of the fact that there were problems. Your Honor, there were problems, and if you give our case the most favorable intendment, that's a summary judgment decision. If we go to fact discovery and they go and they show, you know what, there were no problems at the time. You know what, these things no one knew about them. They weren't material. That's their right on summary judgment. But I don't know how you can.
Thank you, counsel.
Good afternoon, Your Honors, and may it please the Court. Robert Fumerton from Skadden Arps for Defendant Neo. Your Honor, in this case, plaintiffs are seeking to hold defendants liable under the federal security.
Well, so what do you do? We know this. What do you say to this allegation that before the IPO, you knew those batteries were going to explode? You knew there were problems with those batteries and you didn't disclose it?
Your Honor, there's not a single factual allegation in the complaint to support that. We have to go to the complaint. As Justice Ostrager correctly held, plaintiffs don't allege there was a single issue with these batteries, with the ES8 at the time of the IPO. If we look at the record, look at the allegations, the record on 81.
So what about those meetings, the 2017, 2018 meetings, were those not about the battery?
Sure, Justice Garpool, if you look at the allegations in the complaint, record 81, paragraph 73 and 74, the meetings were regarding door sealing closing problems, water leaks, gas struts, aluminum castings, powertrain systems, etc. But the key thing is there's nothing in the complaint to suggest that those issues, which are routine manufacturing issues, weren't resolved at the time of the IPO, much less that they affected a single ES8 customer, a single ES8 vehicle, or had any impact whatsoever on the company. It's just rank speculation to take that allegation and say that therefore the company knew there would be a problem months later. Again, just going on the record here, if we look at the complaint, the only issue with the quality and design of the ES8 that plaintiffs ever alleged was in June 2019, 9 months after the September 2018 IPO. The company announced a battery recall due to a few isolated incidents with batteries catching on fire. And again, on record 82, paragraph 78 to 79, those incidents did not occur until April of 2019, 7 months after the IPO. Your Honor, picking up on Justice Rodriguez's questions, the company also precisely did warn of these risks. Again, if you look at the record on 173, page 33 of the prospectus, the company disclosed in a bold heading, our vehicles make use of lithium-ion battery cells, which have been observed to catch fire, vent smoke, and flame. Same thing on record 165. We may be compelled to undertake product recalls or take other actions which could adversely affect our brand image and financial performance. This court's decision, Justice Kennedy's decision, the Sundial Growers, is really on all fours here. There you had similar disclosures that the company might have to initiate a product recall if these problems develop, and the court held that those were sufficient. And any attempt by my counsel to contend that the risk disclosures were misleading because they discussed only potential as opposed to existing risks fails for the same reason. There aren't facts, there aren't factual allegations in this complaint, in this record, demonstrating there was a single issue with any ES8 at the time of the IPO. Your Honor, my counsel mentioned a statement by the defendant's CEO, and I think Justice Kern pointed out, if you look at the record, look what the CEO said on the earnings call. It was a question about what operational lessons has the company learned in the manufacturing and delivering process of the ES8. That's an R495 to 96. There are zero facts tying any of the statements that she made about operational lessons.
Counsel, what do you say to the plaintiff's allegation that you failed to disclose that the strong performance had been artificially inflated because people rushed to buy those cars before the subsidy was going to go away?
Sure, there's no allegation in the complaint that the company was aware that customers were front-loading their purchases. If you look at what the offering documents disclosed about the subsidy.
Where did that allegation come from? What information is it based on, the front-loading?
Pure hindsight, Your Honor. It's pure hindsight. They're looking at the sales data, and they're looking at the fact that the sales data decreased in 2019. But if you look at what
so from that they extrapolated that everybody
must have known that there were front-loading purchasers. There's no other allegations.
No other?
And look at what the offering documents disclose. They disclosed on record 156 that NEO's competitive pricing advantage depended on the availability of government subsidies. that the Chinese subsidies will be, not maybe, but will be reduced in the future, and alerted the market that the Chinese government had already announced a phase-out schedule for the subsidies beginning in 2019 and 2020. These plaintiffs argue in their brief that the disclosures misleadingly conveyed the subsidies may not be harmful. But, Your Honor, we're talking about the future. The subsidies don't take place until months after the IPO. The company doesn't have a crystal ball.
Thank you
Thank you,
very
Your Honors.
So I'd just like to respond to some of what you heard from counsel. The standard here is documentary evidence. They haven't come forward with a shred of documentary evidence to show that the problems were resolved. It's their burden on this motion to do that. Counsel here referenced these problems as routine. What documentary evidence have they submitted to show that they are routine? I would submit none. There is none in the record. And moreover, the meetings in 2017 and 2018, Your Honors asked the question, they were also about powertrain and electrical systems. That's the battery systems. We also, counsel mentions the Sundial case. One case counsel doesn't mention, I know Justices Scarpula and Kern, you were both on the panel for Erie County. Erie County cited repeatedly in our brief, they barely addressed that case. And I think if you give our allegations the most favorable intendment as they are supposed to be done, this case is squarely with Erie County. Erie County, there were 60% of the company's revenues, 2 of 3 product lines at issue that the court found to be material. Here we have the ES8, 100% of revenues. The only thing that the company was making at the time, the only business line at the time. And Your Honor, we talk about the risk disclosures in this case. Judge Garufis in the Eastern District of New York has already reviewed the risk disclosures. There's another case pending there that has different allegations in our case, but this same registration statement was already found not to have accurate disclosures in it. So,
Thank you, counsel.
thank you, Your Honors.
Fuchs versus Rakia Associates, last but not least.
Good afternoon, Your Honors. If it may please the court, my name is Guy Halperin from the law firm of Guy S. Halperin. I'm the attorney for the appellants. The parties agree that the core legal issue in this appeal is whether the referee's report is supported by the record. And guided by that principle, it is the appellant's contention that with respect to the issues in this appeal, the record does not support the referee's finding. And we have listed a number of issues which we believe are not supported by the record. So, for example,
But the record wasn't before the motion court, was it?
well, the record was not.
Because it seems to me the issue is not as you phrased it. To me, the issue is how could the motion court have confirmed or rejected this report in the absence of the transcript and the exhibits?
Well, that is the threshold question which I do raise in the brief, no question about it. And we presented that issue to the court. We put it in our brief below. We advised the court that if it wanted, we were even willing to provide it with the record. And that is what is very unsettling to the appellants, is that the court did not seek any part of the record. And we, the appellants, in our briefs below, in reliance upon that requirement, we set forth in great detail.
So, counsel, you're not just talking about credibility determinations. You're saying there is no evidence in the record, for example, for $375,000,
Correct.
that number.
In fact,
So it's not like the court could have just said, oh, the referee made a credibility determination.
no, there is no credibility issue. In fact, In all of the issues that we have presented to this court that we believe should be modified, reversed, none of them are based upon credibility determinations. They're based on pretty obvious facts. So, for example, the fraud determination, $375,000 in damages. Clearly, I can't prove a negative. There is no damages for $375,000 or really for any amount, even assuming there was a breach of fiduciary duties. The $521,000 that the lower court determined should be set aside to repay loans, there's nothing in the record. You will not find anything in the referee's report that even remotely hints of that figure. That was a figure that was pulled out of a hat, that's simply planted in an affirmation of an attorney with no support in a table of loans that the court requested, and specifically requested that we provide a table of loans of all the entries that the referee determined were, quote, accurate. Right? So
you're saying the court could not have grappled really with any of these issues without having the record before her?
The court needed to have the record, or at least...
So how can we possibly review then whether the court correctly reviewed the record if the court didn't review the record?
Well...
How can we get into any of these particular details on this appeal where it's undisputed that the court didn't review the record?
Well, what counsel for the respondents and I have done is we have presented a pretty extensive appendix of that record.
Right, but we, as the appellate court, are limited to the record that was before the trial court. We cannot look at things that the trial court did not look at in deciding whether or not to affirm or reverse the trial court. We are limited to their record. So since there was no record before the trial court of any of the underlying bases for these arguments, how can we possibly make specific findings as to any of these issues? Whether they were correct or incorrect to confirm.
Well, perhaps it could be argued that this court is empowered to consider the entire record upon which the referee rendered his report.
Well, again, we don't have the authority to do that. I mean, the appellate court can't review something that the trial court didn't review. So let me hear from opposing counsel, and you'll have a moment of rebuttal, minute of rebuttal.
Thank you, Your Honor. Justice Kern, you're absolutely correct. There's 22 volumes in the record, and all but about 150 pages were not before Justice Crane. And the court is absolutely correct. How could Justice Crane not have the entire record?
But aren't you asking us to affirm?
We are not. It's their appeal. And the bottom line is, counsel is really speaking out of both sides of his mouth, because he moved to confirm without a full record. He did not object to the non-filing of the transcripts and the...
I'm sorry. How could... Normally, you would just attach the transcripts when you're making a motion to confirm. So why...
This wasn't done, Judge.
Why wasn't it done as part of the motion? You didn't make the motion.
I was not counsel of record, but I know this, and this court has held that if the non-filing of a referee's transcripts and exhibits is not objected to in the first instance, it's waived. Here, counsel for the appellant not only did not object, because he only objected on a motion to re-argue and it was too late, and he can't appeal that. He did not object. In fact, he moved to confirm...
Wait. That's not... in the record, at page 341, footnote 2, right, they explicitly raised the issue in their memo of law.
This is what he says. First of all, he doesn't cite the CPLR section. He cites the NYCLR.
But he raised the fact
right, he says, Judge, if you need anything, let me know. That's
but he also raised the fact that it was improper.
He didn't say it was improper. He said it was too voluminous, Your Honor.
That's not what I read it to say.
Well, are you reading from the motion or the re-argument?
No, I'm reading from the record on appeal.
In the record on appeal, there's a footnote. And all he does is he invites the trial court to ask for whatever her honor wants. And that's not what's done. If I have an accident case and there's a police report, I don't tell the trial judge, this is what the police report says. Do you want to see it? That's called hearsay. And that's what he did. But more importantly, whether it's judicial estoppel or waiver, he moved to confirm on that record. And some of the judge's findings sustained the report in his favor. So now he's up here talking out of the other side of his mouth, and he says, well, I don't know how the judge could rule. And that's true, Judge Kern. You should not look at the entire record before the referee if it wasn't before Judge Crane. And that's a failure of proof, and that violates a fundamental tenet of appellate advocacy, to give this court something that the trial court didn't have.
I don't know, how come you didn't give the court how come nobody gave the court the record?
Because they waived it. And this court...
But you had your own, you wanted...
Judge, I wasn't there. I was hired for this appeal.
No, I'm talking,
You
okay.
weren't there, but your client was there, the lawyer
Yes,
for
and
your
both attorneys waived it. They did.
So then how can anybody argue on appeal that it was a problem if everybody waived it below?
Exactly, but that's what he's doing. He's arguing it, and he waived it. That's exactly right, Judge. Justice Pukla, that's exactly what he's doing. And it's infuriating how he just pivots. And then the other thing he's doing is he's giving you 22 volumes of exhibits, cherry-picked. There was 100 days of hearings, 100 days over 7 years. That referee took 3 years to render that decision. It's not a boilerplate referee's report on a foreclosure. It's 85 pages with footnotes, dealing with 16 witnesses, 4 experts, 10,000 documents and evidence. And counsel here, what he does, he just gives you what he wants. He calls it an appendix. And A and B, not only is it incomplete, it doesn't even include the exhibits, many of the exhibits that the referee relied on. And a fundamental rule in this court is a referee's report is entitled to deference for the same reason as any trial finder of fact.
So you're not upset at all with the referee's report? You want us to uphold it?
It should be upheld. There's one problem, there's a footnote at
How can we
A194.
uphold it, though, if we don't know what the basis of, how can we do either thing, uphold it or reject it, if we don't know what the basis was for the trial court's determination?
What you can do, Your Honor, is you can look at what Justice Crane did and say that she was correct.
But
she didn't have...
How can we say that?
We don't have it. How can we say either side is correct?
What she did, on the record that was before her, on the hearsay contentions of counsel...
She didn't have the record, though.
Exactly. And so
she
denied his motion to reject the referee's report. He's appealing from that.
But how can we accept either her rejecting or her confirming without her having reviewed the report?
Because there was no evidence before her to reject it.
But it seems...
Go ahead.
Right?
I just don't understand how we can do anything except send it reverse, send it back to Justice Crane, and with the direction that she consider the application, the motion to confirm with a full record or a record stipulated to by the parties. But in the absence of that, I don't see how we can do anything else given the law.
26 years, it was waived. The law that's cited in our brief, Your Honor, deals with waiver of that specific issue. It was waived.
Where? Okay, I'm sorry. I was just going to ask where it was waived, but there's no point.
Thank you, Counselor.
Thank you.
I find this extraordinary.
I'm not really sure why counsel keeps on saying that I waived it when it's very clear in the motion below when I did raise the issue, so I'm not sure what the basis of that is. And with respect to the appendix, which seems to be moot based on the court's arguments because the lower court didn't have the same papers, but counsel did put in a supplemental appendix. So to the extent he thinks that somehow the appellants did not create a full appendix, he supplemented the appendix. I had no objection to that. Even if the court, though, had the entire record, the court below and this court, it still does not change the fact that we have alleged in our motion below that there is not a scintilla of evidence of monetary damages sustained by the respondent Fuchs with regards to the fraud, the breach of fiduciary duty.
Thank
There's
you,
nothing in the record with respect to that.
Thank you very much.
Thank you very much, Your Honors.